afternoon and welcome to the Appellate Division, First Department. We have about 7 hours of requested argument time. So as I call the calendar, I'm going to tell you what I tell all my groups. Please ask for the time that you need, not the time that you want. Understand that the court is familiar with your briefs, the record, typically more than you wish we were. And also know that the time clock is for you, not for the court. So if my colleagues have additional questions beyond the light, I let the time roll, okay? People versus James Aerson. Okay. Respondent? 4 and 1 and 5. Aguilar versus TMP Wireless. Submitted. Chastity versus Carrillo is submitted. Penguin Brothers versus City National Bank. He's behind you. Appellate. 5 minutes. Do you want rebuttal? Hold on 1 minute. Do you want rebuttal in that 5 minutes? 4 and 1 perhaps? All right, 4 and 1 and 5? You got it. Aguilar Lopez versus an Idust cleaning. Okay. Okay. 5 and 1, 4 and 4. Coranza Rafael versus LRC Construction. Okay. 4 and 2 and 4. People v. MD. Submitted. Katz versus Navios Maritime Holdings. Okay. 5 and 2 and 5. Doe versus Combs. 4 and 1 and 5. Napolitano versus Bounce, 21. Four and 1 and 5. People versus Sandra Tavaris. Okay. 5 and 1 and 3. Martin versus Poe Affiliates. 5 and what? Okay. 5 and 1 and 5. Olympic Galleria versus Sit. Okay. All right. I'm going to do 4 and 1 and 4. Woodward versus J.T. Megan. Okay. 5 and 2 and 5. 382 8th Avenue Realty versus DHCR. Okay. 5 and 2 and 5. People versus Alexandros Lorentos. 5 and what? Okay. 5 and 2 and 5. And Nimmons versus EIC Associates is submitted. First case on the calendar, People versus James Aerson. You may proceed.
Good afternoon, and may it please the court. Jalen Banks Law graduate on behalf of appellant James Aerson. Mr. Aerson's sentence is excessive given his exceptional remorse and acceptance of responsibility, poor health, advancing age, and lack of felony offenses for over 2 decades. A reduced sentence would fully serve the aims of the penal sanction and is warranted in the interest of justice. Additionally, the appeal waiver is invalid under the totality of the circumstances and should not stop this court from reaching the merits of Mr. Aerson's case.
Didn't the court's colloquy track the model colloquy? So why is it inadequate?
That's correct, Your Honor. But Mr. Akerson was required to sign the appeal waiver form prior to the court's explanation on the consequences of
He
waiver.
was required to, or his lawyer took the time to go through it with him? Didn't he say on the record, I reviewed the appellate waiver with him and answered all his questions, Your Honor? That sounds to me like he had a full review of the waiver. So why is that a problem?
I understand that, Your Honor, but the issue with this ordering of the signature on the waiver form versus the court's colloquy is that it made Mr. Akerson, who had not participated in a proceeding of this nature for over 2 decades, feel locked in and as though he could not refuse to waive his right to appeal after the signature was placed on the form. And so, again,
And what in the record indicates that he felt locked in, as you say? He was asked questions, was permitted time to talk with the court, never objected to anything, said nothing to probation about it.
that's right, Your Honor, but it's our position that this is an issue inherent anytime that you have a defendant.
Except that our precedent in this court has repeatedly affirmed where the signature is obtained ahead of time, so long as all of the other indicia of knowingness and voluntariness exist on the record. So is there anything in the record that would indicate the opposite of that?
Well, I would just like to underscore, Your Honor, that it's not this one factor alone. It's the totality of the circumstances. So it's not just this order of the signature and the court's colloquy. It's additionally the fact that Mr. Akerson has a limited educational history, which other courts have recognized as a factor that can render an appeal waiver invalid. And additionally—
Counsel, in this case, the judge started off the colloquy by saying, New York law requires that I discuss this with you to make sure that you understand it. And he seemingly understood that and all of the questions that followed.
That's right, Your Honor. But again, it's not any one of these factors taken individually. It's all of the circumstances combined that we believe render this appeal waiver invalid, especially considering the merits of Mr. Akerson's case. So turning briefly to those—
What do you mean by that, especially considering the merits of his case?
Just to highlight that ultimately, again, the merits of Mr. Akerson's case, along with the invalidity of this appeal waiver, warrant this court's consideration.
The merits of his case, to the extent that he stabbed someone in the heart with a machete and they died?
That's correct, Your Honor.
Oh,
Mr.
you're saying
Akerson—
that because it's a serious case, we should look even more closely at the waiver?
Not necessarily, Your Honor. What I mean to say is that the merits of Mr. Akerson's case, including his unwavering contrition for the severe conduct that he committed, again, is a factor that weighs in favor of a sentence reduction here. One of Mr. Akerson's earliest questions to trial counsel was about when he would get—
Oh, you were talking about mitigation, the mitigation present in the case.
the merits of his case. That's correct, Your Honor.
Counsel, has he pleaded, entered guilty pleas before in his prior convictions?
Could you repeat that question? I'm so sorry, Your Honor.
Is this his first time entering a plea?
No, Your Honor, but this is his first time entering a plea in over 2 decades. So this was the first time that he was participating in a proceeding of this nature for over 20 years.
Okay, you'll have time on rebuttal.
Thank you.
All right, you can proceed.
Good afternoon, and may it please the court. My name is Samantha Valente, and I represent the people turned respondent in this matter. The respondent respectfully requests that this court affirm defendant's sentence for 2 key reasons. First, the defendant executed a valid waiver of appeal, and second, the defendant's bargain for sentence is not unduly harsh nor excessive. Beginning with my first point regarding the waiver of appeal, the totality of the circumstances demonstrates that this is indeed a valid waiver of appeal. First, the trial court's colloquy, as Your Honors have pointed out, tracks the model colloquy and explain that the waiver of appeal is separate and distinct from the rights that the defendant waived in the guilty plea allocution. Second, the record is replete with instances where the defendant affirmed his understanding of the proceedings as they took place. Moreover, the defendant had access to not one, but two attorneys to explain the proceedings to him. Additionally, defendant signed a written waiver of appeal that supplemented the oral colloquy. Ultimately, defense's arguments regarding the waiver of appeal are unavailing because the trial court did in fact apprise defendant of his right to a counsel on appeal, and this court has repeatedly stated that, oh, I apologize. And the trial court did in fact state that if the defendant cannot afford the cost of an appeal or an attorney, that the state will bear those costs, and that is in the second plea proceeding minutes on page 5.
Counsel, how do you handle the mitigation raised here, that being the defendant's consistent regret and remorse along with his health issues? How do you handle that in terms of how we weigh that in determining whether this is an excessive sentence?
Yes, Your Honor, it's a fine balancing that must consider the purpose of the penal sanction with the defendant's circumstances, and the penal sanction here is to ensure that the public is safe, and here you'll see that the defendant, this is his third violent felony conviction, and this one was for murder. I apologize, not for murder, for first-degree manslaughter, where he stabbed a man in the heart with a machete. And yes, the defendant does have asthma and sarcoidosis, however...
There's no question. It seemed very apparent from the record here that this was some aberrant behavior. Not that it excuses it, by no means. But this defendant was kind of dealing with a lot of grief. He had just lost his wife, right, or his living girlfriend, had recovered from cancer of the most delicate nature. So there were a lot of things on him. Are those factors that we should consider in considering counsel's request for further reduction?
Your Honor, while these are factors that you may consider, it is important to note that the trial court did already consider these in the sentencing proceedings below. They had the pre-sentencing report in front of them, which laid out all of this information.
And am I correct that the people requested 20 years as a sentence on a plea for this case, and the court undercut the people and offered 16? Correct?
Yes, Your Honor.
Which is 1 year above the minimum, is that right?
No, Your Honor, it's actually unclear from the record as to where the 16 years came from. It seems to have been an off-the-record agreement that was made between the defense attorneys and the people below. However, the fact that the defendant pleaded to the 16-year sentence further indicates that this was not an excessive or unduly harsh sentence because...
Am I correct that it's 1 year above the minimum?
No, Your Honor. The defendant pleaded to first-degree manslaughter,
Right.
and that carries between 5 and 25. He did, however, get 1 year over the minimum for the second-degree murder charge for which he was indicted, and for that he was facing life in prison.
Ah, okay, got it. Okay.
Yes, Your Honor. And further, because of that, this points even more to the fact that this sentence is not unduly harsh nor excessive. And in fact, this agreement was definitely motivated by the fact, or rather the defendant's acceptance of this agreement is further motivated by the fact that he was potentially facing life in prison. This was a strong case. There were 2 witnesses who observed the altercation between the defendant and the decedent, and there was surveillance footage and 1 witness who saw the defendant carrying away the machete or alleged machete that he used to stab the defendant in the heart with.
Thank you.
Thank you.
You have 1 minute.
2 quick points regarding the appeal waiver, Your Honor. First, the second department has held that timing matters. We are well aware that this is the first department. However, the issue of sequencing is also, regarding the written waiver, will also be heard before the Court of Appeals in the fall. And so that's just to highlight.
If they tell us different, then we will change our tune.
Understood, Your Honor.
Okay.
But that's, again, just to
We're
highlight.
not going to do it now preemptively.
Understood. And turning very quickly back to the merits of Mr. Ackerson's case, as the prosecution's brief aptly highlights, the heart of this court's sentence reduction calculus is whether the court is confident that an individual, like Mr. Akerson, will not cause further harm to the community if released. Given Mr. Akerson's deep and sincere remorse, his largely law-abiding life prior to this severe offense, and his deteriorating health, it's clear that he is no danger to society, and a reduced sentence will still serve
I
the
don't know that that's clear, but I accept your argument as his advocate. And let me say on behalf of the court, we thank you. We understand that you are practicing under the student order, and you did a wonderful job. You both did. Thank you.
Thank you.
D. Penguin Brothers versus City National Bank. You may proceed.
Good afternoon, Your Honors. May it please the court. George Frank here from McCabe-Weisberg.
Please keep your voice up. I can't
Yeah.
hear you at all.
Sorry about that. George Frank from McCabe-Weisberg in Conway, representing the
It's not any better.
proposed
I
intervener.
need you to, no, don't put it lower, put it right in,
higher? Yeah.
right by your mouth so that we can hear, because you're kind of talking like this.
Thank you.
Can't hear you,
Thank you, Your Honor.
okay? Yeah,
Yes, Your Honor.
let's try that again. I want to hear you,
I do.
okay?
Again, George Frank from McCabe-Weisberg, representing proposed intervener, defendant appellant, U.S. Bank National Association, the successor in interest to Greenpoint Mortgage. We're here on appeal of a three.
Counsel, aren't you here kind of late? Like, in terms of trying to intervene in this action, isn't it untimely?
Not really.
Not really?
Not really, because the timeliness of the action, I think, was brought up.
It's usually a yes or a no.
No, well,
No,
it's been
no,
argued.
seriously. It's either you're timely or you're not. There's no in-between in the law on timeliness. So either you're timely
We are
or you're
timely.
not.
We are
Okay.
timely, and the reason we're timely, we filed our motion while the pending appeal was waiting to be perfected.
But counsel, was an entry of judgment effected on July 31st, 2023, and wasn't the motion to intervene approximately 6 months later on January 30th, 2024?
I believe it was still pending perfection. So we were,
Moving to intervene after the judgment was entered and they've appealed, so you want to intervene in the appeal?
correct, because we believe,
And how is that timely? Is the question you have been asked several times now, because the time to appeal a judgment has to be before the case gets to the appeal court.
correct,
And you didn't do that. So why is it that this is an action that doesn't warrant dismissal?
because the judgment was entered, excuse me, because the money judgment was still pending, appeal was pending perfection, and the collectability of the judgment that has been questioned is really related more to the argument that would be really attributable to hearsay that's was never part of the record.
I don't
Sir, do you have a-
understand you. You're saying that the enforcement of the judgment is relevant to the timing of the motion to intervene?
It has been suggested that it was, but my argument is that we weren't too late to appeal because that appeal was still pending perfection. So we believe we're timely on that.
What case stands for that proposition?
I wasn't anticipating the timeliness argument. I
Whenever
believe that
you
is in our
anticipate
brief.
an argument, counsel, you should anticipate backing it up with law. So I ask you again, what case law stands for the proposition you are asserting here today?
We are asserting that we.
I know what you're asserting. I want to know what case supports your position.
I
You
don't have-
deal in law.
Right.
So tell me
I don't
what
have the
case-
supporting case before the court.
You have no
I don't
supporting
have the
case
sup-
for this proposition of yours? Is that your answer?
I don't have that before the court at the moment.
Okay. Your time is up. You'll have time on rebuttal.
Good afternoon, Your Honors. My name is David Gordon. I'm here from the firm of Gordon and Hafner, and we represent the respondent. Just addressing the question of the lateness of the motion below, I don't believe that the pending appeal has any effect on the timeliness or non-timeliness of that motion. I think a judgment once entered, unless and until it is reversed by the appellate court, is presumed to be regular. This motion to intervene, if it was to be made at all, should have been made long ago, certainly well before the entry of the final judgment, preferably before the trial, which took place months before the entry of the judgment.
In that connection, I guess the reason the law imposes a time requirement is to avoid prejudice. So in what way, sir, is your client prejudiced by this belated application for intervention?
Well, on top of going through a trial on this and all the preparation and the presentation of evidence that's required by that, after I think it was 9 years of litigation, I think that going back and opening the judgment they have justly earned is extremely prejudicial on its face.
So are
It
you
also sets
suggesting,
back their ability
Counsel,
to
are you-
enforce that judgment, assuming that there were assets to go after.
I think my colleague has a question.
Certainly.
Are you suggesting that there would have to be a retrial if the motion to intervene was granted?
Well, that would really depend upon what the appellant intends to present. I don't even see grounds for a new trial. I don't even see, they've made a motion here for summary judgment. I don't see how they prevail on that. The idea here that my client was unjustly enriched by a money judgment it got to remedy the theft of its funds is so bizarre. I don't even know how to address that.
Is
And
it
if
still,
they had wanted to intervene, didn't they have two opportunities to have done so, like one in 2014 and one in 2015?
I'm sorry, I don't think I understood the question. Didn't the appellant have the?
They had the opportunity to intervene in 2014 and 2015.
Oh, I'm sure they did. It's pretty apparent from the record that they were monitoring the action below. And they knew, for example, when final judgment was entered in favor of my client, and they also attached exhibits to their motion that they got from the NYSCEF docket. So they were following this action. Why they didn't make a motion to intervene in 2014, 15, 18, 19, 20, 21, 22, I can't answer, unfortunately. But it's
Counsel,
bizarre.
are there also any common questions of law or fact here?
Not that I see. The unjust enrichment counterclaim that they're trying to assert doesn't raise any questions that are raised by our claims for conversion, for fraud, for breach of fiduciary duty, and conspiracy to breach fiduciary duty. I just don't see any commonality there. The other point that I'd like to address that was raised by appellant in its brief was this notion that my client should have advised the court below of the fact that it had succeeded in getting the foreclosure action dismissed and the mortgage canceled of record. I don't understand under what theory of law we had a burden to bring that to the court's attention. We didn't have to plead it. We didn't have to submit evidence on it. And it's really unrelated to the facts here on which my client's recovery of a judgment relied. The reason why appellant lost money on this was that it allowed the statute of limitations to run out against my client on his foreclosure claim. There's nothing unjust about that. And if this court were to conclude that unjust enrichment lies for that, it would upend all of the jurisprudence that I'm aware of on the question of statute of limitations. It would be an instance of taking away from from the appellant for having violated the statute of limitations and giving the benefit back in terms of a money judgment for unjust enrichment. It just makes no sense.
Okay.
Can I help the court with any other? Okay, thank you.
Counsel, you have a minute.
Thank you, Your Honor. I would just add that CPLR 5015 allows the court, in its discretion, to vacate orders and judgments based upon new evidence. That new evidence being precisely what counsel was discussing, which is that the lower court wasn't aware of the dismissal of the foreclosure actions and the removal of the list pendants and mortgage.
Is a
Therefore,
party
my-
seeking relief under 5015 for newly discovered evidence, is there a diligence requirement imposed on the party seeking that relief?
The diligence requirement would be that the lower court would have been informed of the outcome of those. It was glaringly omitted. If the lower court knew that the mortgage and lost pendants were removed,
I don't think the
they would
question
have
was,
looked at this
I don't think the
completely
question was with regard to the diligence of the court. It's with regard of the diligence of the moving party.
different. Correct.
Meaning you, as the intervener. What due diligence was demonstrated by your clients in this regard?
Our due
In
diligence,
light of the fact that it's clear from this record that you were aware of this litigation since 2014.
and we sought to intervene, we believe
How
timely.
many years later?
2024?
Once
10 years later.
correct, Your Honor, but once
Okay.
that judgment was rendered and we had no remedy other than the unjust enrichment claim because the mortgage was removed, that was our sole remedy, and we were denied the ability to intervene, to
Thank
at
you.
least inform the court. Thank you.
Thank you so much. Aguilar Lopez versus Idust Cleaning. You may proceed.
Good afternoon, Your Honor. May it please the court, my name is Mona Patel, here for plaintiff appellant Lydia Aguilar Lopez. Our position is that in granting the summary judgment to Idust Cleaning Services, Lafayette retail owner, and Lafayette Street Partners to plaintiff's negligence claim, it was done in error. Because first, the landlord or 380.
Well, the landlord is an out-of-possession landlord with simply the right of reentry for structural defects and the like. How, under our jurisprudence, under these facts in this case, would we hold in the landlord on this fact pattern?
Well, the lease is clear in stating that the bakery tenant did not have exclusive access.
The lease was clear that the tenant had to hire a professional cleaning crew to the liking of the landlord, so that the entire shift of that responsibility was on the tenant, not the landlord.
Well, it also required the landlord's approval for the maintenance and the alterations to property, or even the care to the property. So in our view,
What in the lease requires that, as with regard to what we're talking about in terms of maintenance? It just says the landlord and agent shall have the right to re-enter premises at reasonable time to show prospective purchases and mortgages.
in the record on page 617 and 636 and 637, it says that the landlord does have to, or I'm sorry, the bakery tenant does have to seek the landlord's approval for care, maintenance, and alterations to the property.
Well, but that's a standard provision in every single lease in New York City. There is no landlord that allows alterations to their property without their approval. So that is meaningless in terms of the analysis on this fact pattern. We're dealing with someone who slipped on what she claims was a wet staircase, right? So let's focus. And so the question is whether there was something that the landlord did, and we know he's out of possession. So I think that's the weakest part of this. Let's focus then on the bakery, who's her employer, right?
Yes, correct. Now, as far as the bakery tenant summary judgment motion, we find that, or our position is that they did not meet their burden for their prima facie establishment of summary judgment. They didn't provide any medical evidence. They overlooked.
They need to
Medical
provide
evidence.
medical evidence.
Well, because
And liability, the medical evidence is for damages, right? So that's irrelevant on an issue of liability. Summary judgment on liability, we don't get to that issue at this stage.
Well, because their argument is that the plaintiff didn't sustain a grave injury as defined by the Workers' Compensation Section
Okay.
11.
I see.
They didn't provide that medical evidence showing that there was no grave injury. Now,
Isn't the grave injury exception an exception where either indemnification or contribution is sought? The underlying tort action, as I understand Section 11, the exclusive remedy of the worker is the workers' comp benefits vis-a-vis the employer. The grave injury exception comes into play where defendants or third parties in an impleader action are disputing contribution or indemnification.
yeah, and while that may be correct, our position is that in the summary judgment action, they didn't meet their burden to even come to plaintiff's argument, to plaintiff's opposition. They didn't meet their prima facie burden in showing that a grave injury was not had here by the plaintiff.
Right, but the question is, did they have to show that, right? Given that they're the employer.
Our position is that, yes, they did have to show that they did have to show that, as a matter of law, that they're not liable under a grave injury, under the grave injury exception under the Workmen's Compensation Law, Section 11. And also moving to Idust's motion for summary judgment, our position is that Idust entirely displaces bakery's duty to maintain the premises.
So could you explain that? Because isn't it the case that Mr. Albuquerque testified that he mopped during the day and someone else mopped during the night?
That's correct, Your Honor.
So wasn't there a bifurcation of responsibility and duty?
Well, during the time that the plaintiff slipped, which was considered to be 6:58 a.m., it was during the time that Idust would have been present and had the contractual duty to maintain this.
Actually, they were done with their work by 7 a.m., and you just said 6:58, but you'll have time on rebuttal.
Thank you.
You may proceed.
Good afternoon, Your Honors. As it pleases the court, Stephen Ingrassia from Cuomo LLC for the defendant respondent Idust. It's respectfully submitted that the lower court correctly granted summary judgment to Idust, dismissing all claims and cross claims against it. Plaintiff's bill of particulars only alleged facts giving rise to the spinal exception, the only way that Idust can bear any liability in this action as a third-party contractor. Sorry.
Spinal.
Thank you, Your Honor.
Okay.
Thank you, because I didn't understand what you were saying.
Go ahead.
I appreciate it, Your Honors.
All right.
For the launching of an instrument of harm. Here, all the evidence, mostly from plaintiff, demonstrates that Idust did not launch this instrument of harm. By the time plaintiff arrived, Idust was gone, and the plaintiff used these stairs twice, and the stairs were dry.
What evidence in the record is there that Idust was already gone?
Yes, plaintiff herself testified that by the time she got there, they weren't there. Mr. Albuquerque for Lafayette Street Partners 2, the bakery itself, said that he got there 15 minutes earlier. They were already packing up and leaving. And then by the time plaintiff's there, they're gone. She then proceeds to use these stairs twice, and she doesn't notice any wetness on the stairs. It's only then on her third trip down, long after Idust is gone, that she claims that there's wetness on the stairs. That evidence unequivocally shows that Idust, who's no longer there, could not have possibly created this condition. They couldn't have created that instrument of harm. That entitles them to summary judgment on that exception. There's no allegations giving rise to either of the other two exceptions to liability. That made my client's prima facie demonstration on those 2 points. It was argued at the lower court and on appeal extensively regarding contractual displacement. It's just not, it's not the case here. At a very basic level, my client has an overnight cleaning contract for 7 hours a day, for 7 hours a night. When that's not in effect, the bakery maintains responsibility for this. Mr. Albuquerque from the bakery again testified that when I'm not there, they clean these stairs. He even testified that if he noticed wetness on these stairs when he's not there, they would have been the ones that would have cleaned it. All I have here is a 7-hour contract. Notably, there's this Lopez case cited in my brief. The court in that case, the appellate division, says that unless it's a 24-hour contract that displaces the tenant or the owner, that's not comprehensive and exclusive. This contract that doesn't even have an indemnification or a hold harmless agreement is not comprehensive and exclusive. There's no contractual displacement.
As to detrimental reliance, is there any heft to that argument?
Your Honor, there's nothing with detrimental reliance. It's never been seriously argued. The only thing I want to point out is that in the reply brief, there is the reply brief at the appellate level for the first time. There's something that says, yeah, plaintiff would see my client and sometimes they would say, hey, be careful, we just mopped there. That's frankly just not the testimony. That's the record at 121 to 122. The plaintiff's testimony is very clear. She would go to work. Sometimes she would see my clients there. Sometimes she wouldn't. And on those times that she would sometimes see my clients there, she would be in the basement and she would overhear my client say something to someone about, watch out, it's wet somewhere. That hearsay evidence cannot be considered because it's the only evidence offered trying to raise an issue of fact. But then even beyond that, it's her testimony on the day saying there's no wetness, and then with all the evidence regarding the contractual displacement, there's no reasonable detrimental reliance in this case.
Thank you.
Thank you, Your Honors.
You may proceed.
Good afternoon, Your Honors. May it please the court, Christopher Yapchanik on behalf of both Lafayette Owners, the landlord, and Lafayette Bakery, plaintiff's employer. Briefly about the workers' compensation issue. The facts are very simple. First, we employed the plaintiff. Second, plaintiff applied for and received workers' compensation benefits. That's the only two relevant facts under sections 10 and 11 of the compensation law. Plaintiff is not permitted to file a claim against us in tort. Compensation is the exclusive remedy. The whole grave injury argument is, as Your Honor pointed out, is relevant only if I'm a third party seeking indemnity from the employer. That's the simpler of the two issues. As to the out-of-possession landlord issue, plaintiff can only argue a potential liability against us if there was some argument that we had both a right of re-entry to make repairs and maintenance, and there's an allegation of a significant structural deficit. This court's decision in Malloy versus Friedman clearly holds those. That's a conjunctive test. That's not the issue here. The issue here is simply a wet transient condition. There's nothing structural about that that would provide us with any potential liability. Unless there's any questions, I'll rest on my brief.
Thank you.
Thank you, Your Honor.
You have 1 minute.
Okay. I would just like to address one thing. Defendant said that plaintiff did not, that she went up and down the stairs multiple times and did not slip until her third time. And that is not that's not dispositive in this case, like whether she fell the first time she went up the stairs or down the stairs, or whenever we're talking about the third time or whenever she fell, and that is what we're talking about here. And we find that the defendants didn't meet their prima facie burden to establish that there was no negligence as a matter of law, because they did not meet their burden under the summary judgment requirements, and that we respectfully request the court to reverse this order and reinstate the plaintiff's complaint. Thank you.
Thank you so much. Coranza, Rafael versus LRC Construction.
Good afternoon, Your Honors.
Good afternoon.
I represent defendant appellants, L-Corp 55 Bank Street LLC, LRC Construction LLC, and WP South Tower LLC. I realize standing before you, I do have an uphill battle here.
Not because of me, because of your case, but go ahead.
I know. So I would like to start with just focusing on the plaintiff's burden on a motion for summary judgment, that what he offers, of course, is his testimony. And we contend that his testimony itself has certain internal inconsistencies that, if well examined by the court can see that whether we're talking about someone being on a 8 to 10 foot ladder, or even somewhere on the ground or near the ground on a standard ladder, because at one point he does testify things like when he lands, then he's standing, versus his other thing where he says he's on the one ladder and then he tilts back and then he's on the other ladder, and then he's falling and he doesn't remember various gaps in there. And he's also he injures his hand when he's was that from nailing something or grabbing something, which
You mean when he was trying to prevent himself from falling and he grabbed onto a piece of metal that cut his hand?
Right.
Just as he fell off the ladder that was unsecured by your client? You mean that ladder?
if you if you're looking at that ladder. Now then, let me move on to talk about. Well, I recognize the court went into great detail step by step here, but I stand before you as the attorney who got into the case after the clients changed counsel. By the time we became counsel, it was too late for us to even do a re-argument or anything along those lines to try to correct some of those other issues. Now, while I will stand here and continue to try to contend to you that our accident reports were valid business record and that they should be considered, we obviously had a problem here in that there wasn't a proper certificate of interpretation on Mr. Delgado Sanchez's
Doesn't that
affidavit.
kill it, counsel?
What?
Doesn't the absence of an affidavit of translation, doesn't that kill this,
Well, that
your argument, like
I
dead on the spot?
I would like to propose the possibility that here we have that the court, it was an improvident use of discretion for the court not to permit.
We don't even allow Spanish-speaking jurors
Yeah.
to interpret something they hear on the stand and can interpret for themselves. We don't allow jurors to do that. So to relax a standard for the receipt of evidence is not something that obviously we can do, because the impact of that doesn't just impact this case, but every single case that has a language interpretation piece of evidence introduced. But I will hear you on rebuttal, okay?
Okay, and just with regard, yes, and as we obviously, some of these same issues will bear on the RICO amendment.
Okay, we can discuss that in your remaining time. Counsel.
Good afternoon. May it please the court, Vincent Chirico for the plaintiff respondent. To counsel's first argument, there's no question that plaintiff yet testifies he's on the 6th step of an 8 to 10 foot A-frame ladder. He makes sure it's open, locked in place. When he does that, he finds that it's shaky and wobbly. He has no other ladders to use because the only other ladder for this employer has is a 4-foot ladder that doesn't allow him to get to the top. So he continues to use this ladder, and it remained unstable. And at a certain point, as he's up on the ladder, it's its instability.
So
it causes
counsel,
it to
your
move
reading
its
of
way.
the deposition is that there's no internal inconsistencies in the plaintiff's testimony?
Our position is there are no internal inconsistencies. Now, counsel would point to the incident reports and the affidavit. I would submit that even if those are considered, even if you had a certificate of translation, even if the proper foundation was laid for the accident reports, the fact of the matter is that Mr. Delgado, who signed that affidavit, wasn't there at the time. He only testifies, on page 816 of the record, plaintiff told me, Mr. Coranza told me that he lost his ballots. So if you, Your Honor, consider that an inconsistency in his testimony, I would point the court to the Pilapanta case, where
Well, he testified he was on the ladder and it was shaky, and he starts feeling his body fall back.
and he tries to hang on to this metal piece,
Cuts
can't
his
do it,
hand.
and he falls. Whether he falls standing or some other way, he is injured. There's no question about that. The Pilapanta case is one where this court last year said the ladder remained upright. That's what the supervisor said, and the court held that it doesn't matter if it's upright or not. Either way, he has satisfied his prima facie burden on summary judgment. I would also point the court to the Aguilar case, also a 2025 case from this court. There was a video that showed that the ladder remained upright. These inconsistencies have over and over again by this court have held, or these variations that have held that they do not defeat summary judgment where that statutory violation is established. Now, just a point on the separate part of the appeal on the motion to amend the answer. There is no evidence whatsoever, no specific evidence tying any fraudulent allegations to either Mr. Coranza or to his medical providers or to his attorneys. The entire basis for the motion to amend was the correlation to the unfounded allegations in the separate RICO actions. That's all there is. Those
And that
RICO actions.
that involves the surgeon that performed surgery on the plaintiff and his attorney as well, right?
And the firm to which I act as of counsel today.
And the law firm.
And the law firm. Those RICO actions, by the way, have been dismissed. And they're presently on appeal. But there's no specific, all they point to in their brief and in the record down below is some differing opinions of the medical doctors as to what damages were caused, what injuries were sustained, and the extent to those injuries, when they were reported. Defendants have a full opportunity to challenge those on cross-examination at trial. This is not a fraud issue, it's an issue of damages. That's the entire purpose of a damages trial.
Thank you.
There's no other questions?
Thank you so much.
Thank you.
You have a minute, counsel.
Your Honors, I would like to return to the issue of the incident report, reports that we have. And the incident report, we believe it was a proper business record. Peter Zaborski, who was our witness, who did testify, was a person who, obviously he didn't see it happen, but he was the person who the plaintiff got a little first aid from at the work site before he went to the hospital. He is the person who is properly in a position to be provided
Counsel,
with
does
accident
Does he speak
reports.
Spanish?
Yes.
Does he speak Spanish? Because this plaintiff only speaks Spanish.
I do not.
I don't remember seeing that in the record.
No.
So anything that he says is based on hearsay, because someone would have had to translate whatever that Spanish-speaking gentleman was saying to him. That's hearsay, inadmissible.
And again, we go from that. We then, of course, have to go back to how we address Mr. Delgado Sanchez. And I just submit to the court that, again, a close examination of plaintiff's testimony does raise those issues.
Thank you.
Thank you.
Katz versus Navios Maritime Holdings.
Thank you, Your Honor. Jessica Zeldin on behalf of appellants. Through this action, appellant seeks to enforce Respondent Navios' contractual...
Counsel, could you make your appearance, please?
I'm sorry, Jessica Zeldin on behalf of appellant.
She did say it? Oh, God, even with this? Thank you.
As I said earlier, through this action, appellant seeks to enforce Respondent Navios Holdings' contractual commitment to pay dividends to its preferred stockholders, which dividends it agreed to pay in New York. The primary issue on this appeal involves personal jurisdiction, and in particular, whether...
Counsel, what are the contacts that are here in New York that would render long-arm jurisdiction applicable?
There are many, and they are varied. They are all detailed in our briefs, but I will highlight a couple.
So it's not just a banking transaction, right?
It's not just a banking transaction, but the banking, and it's not a banking transaction at all. This is the issuance and maintenance of an entire American depository share program that was listed through New York issuers, through a New York listing on the New York Stock Exchange, and importantly, through a New York depository, Citibank. Citibank was not just a bank where Navios had a bank account. Citibank was its contractually designated attorney in fact, and it performed core issuer roles, roles that typically an issuer would perform, and it did so here in New York. In particular, it received the dividends that are at issue. It then converted them into US dollars, it withheld taxes, and it withheld its fees. And
Is this a case where the complaint is about the acquisition, or is it about the breach of contract?
it's certainly about the breach of contract, thank you, Your Honor. It has nothing to do with the acquisition. The acquisition was the trigger for the contractual obligation, but the contractual obligation was to pay dividends in New York. And it's very important.
Guided by the payment of dividends is guided by the contract.
Exactly, the certificate of designations, Your Honor. So to the extent Navios wants to rely on Your Honor's decision in Sphinx, it's completely distinguishable. That case involved a foreign merger and decision-making overseas. This case involves a breach of contract, and a breach of contract where the primary obligation was to pay dividends, and defendant Navios purposely put in those documents that it would pay the dividends here in New York. New York was the required place of performance, and numerous New York cases have held that in a breach of contract case, if you have formation of the contract or an alleged failure of contractual performance in New York, you have the jurisdictional nexus in New York. And that is precisely what we have here. As I said earlier, importantly, Navios agreed to pay the dividends that are issued in this case to and from New York agents. It made New York the place of performance.
Counsel, could you address the choice of law provision in the depository and the underwriters' agreements and how they're applicable here?
Well, they all help for our jurisdictional nexus, Your Honor, because they are all our New York choice of law provisions. And certainly here, where the core obligation at issue in the case is the payment of dividends, and they are due in New York, and those dividends are to be paid through New York agents to an account in New York, then this court should find that plaintiff's claim, according to the applicable test, which is in some way arguably connected, where you agree to pay dividends in New York through New York bank accounts, through a New York depository, you have created a situation where your claim is in some way arguably connected to New York. And
Didn't they raise $115 million through the New York markets?
they certainly did, and Your Honor, we would also suggest that that goes to formation. And again, formation of a contract in New York is one of the jurisdictional nexuses.
And New York law, that was the choice of law?
Choice of law in the depository agreement, it was. And using a New York underwriter and a New York listing, that's basically putting up like a shop front and saying, we are here in New York, come buy from us, and they made these core obligations, they offered them in New York, and they were supposed to pay them in New York.
You'll have time on rebuttal. Proceed.
Good afternoon, Your Honors. May it please the Court, Israel David on behalf of Respondent Navios Maritime Holdings. I am here to respectfully request that this Court affirm the decision issued below by Justice Crane, which dismissed this lawsuit for lack of personal jurisdiction. I want to start by being crystal clear about what plaintiff's claim against Navios is in this case. There's a certificate of designation, contract. Plaintiff says that Navios breached that contract. And specifically, they point to Section 6F. This entire case boils down to a single cause of action for breach of contract, specifically 6F of the certificate of designation. 6F is a negative covenant. 6F says, when dividends on the preferred stock are in arrears, Navios and its affiliates may not acquire common stock. That's the negative covenant. That's the claim. What plaintiffs say...
Where were the dividends supposed to be paid? They were supposed to be paid in New York?
Absolutely not. I'm sorry, but they were supposed to be paid from Athens, where the company's headquartered, to disperse preferred stockholders around the world, including...
What institution was going to disperse those dividends? Which institution did the company select to disperse those dividends?
Currently, that's Citibank.
In New York.
Citibank is in New York.
Counsel, I would suggest to you that you not avoid direct questions of this court. We notice when you don't answer our questions, okay?
Right.
So it was in New York, correct?
No, I'm sorry.
No?
That's not.
That's not. You said Citibank. Which Citibank? The New York Citibank?
The New York, exactly. It's the New York
No,
City.
New York.
Yeah, Citibank is in New York. But, Your Honor, the dividends go from the company in Athens, and they go to stockholders around the world, including this
But
plaintiff.
counsel, the certificate designation, right, didn't it have the payment time via New York City time, like during New York banking hours?
Right. The certificate of the...
Because you're telling me about Athens, right? But when you set up how you're going to make those payments on a dividend, the way that you're going to make the payments on a dividend is within banking hours via New York time, not Athens time.
5 o'clock, I believe.
That's exactly right, Your Honor. It's
Okay.
the New York Times. They are not suing on the depository agreement that mentions the New York and that mentions Citibank. They're not suing on that. That's not even mentioned anywhere in the complaint, and we say that in our brief. They're suing on a certificate of designation saying you acquired stock when you weren't supposed to.
Because you didn't pay the dividends that you were supposed to pay, right?
Exactly. The company had not paid dividends for 8 years.
And you could not have acquired those stocks without having paid those dividends.
That's exactly right. That's the breach, the acquisition. The acquisition was done through a merger. That's a foreign merger that occurred in the Marshall Islands.
That's exactly right, because I'm not saying that that's the breach. What I'm saying to you is that in terms of paying the dividends, they didn't get paid the dividends that they were supposed to get paid.
That's exactly right. They did not get paid the dividends.
And that is the breach of the contract.
Oh, no, that's not a breach of contract. That's the trick.
The whole point is to get paid
Right.
the dividends.
Right.
No investor gives their money, oh, just keep it. We don't want to see it anymore. You invest so that you get dividends. Counsel, that is the whole point, right?
With one difference, Your Honor. They are welcome to sue for not getting dividends. They did not sue that. If they did, it would be dismissed. They would be sanctioned. For 8 years, the company didn't bring dividends. The best plaintiffs and firms in the country have sued this company over those 8 years. Southern District got dismissed, but never, not this plaintiff, any plaintiff has sued for not paying dividends.
So what are they suing? They're suing because the company sort of paid itself first? And
No, they're suing because an affiliate of the company acquired common stock when dividends were in arrears. That acquisition did not happen in New York. It's a completely foreign transaction, just like Justice Chan's decision in Sphinx, which followed Justice Capula's decision in Palms versus Dominion Diamond. This is a completely foreign transaction. Justice Crane heard all of this, went through it in a 1-hour oral argument, and said this breach of contract does not
Counsel,
arise.
didn't we already hear your adversary distinguish my colleague's decision from the facts of this case?
The only distinction, Your Honor, is that Justice Chan's decision in Sphinx had more New York contacts in this case. This merger, the breach, had no contact with New York whatsoever. In Sphinx, there were 4 contacts. There was a New York transfer agent, New York lawyer, New York information agent that coordinated.
There were mere links to the larger activity that was abroad, so it was distinguishable.
Yeah, no, in Sphinx.
No, it's her decision. She just told you what it was.
But
Good luck with that. Go ahead.
right, yes, that was my case, Your Honor, and we thank you, Your Honor, very much for dismissing it. In that case, the breach of contract did not occur in New York, and here too, the alleged breach of contract happened in the Marshall Islands. The alleged breach, that's the smoke and mirrors that you're hearing here. The smoke and mirrors is they're trying to make it sound like it's a case for non-payment of dividends.
Counsel,
they didn't sue for that.
I have to say, I'm listening, and the only issue that is before us right now is jurisdiction. And your adversary has listed contacts from the paying agent to the payment of dividends to the choice of law, to the selling of preferred stock through the New York Stock Exchange. And I might add, doesn't the website for Navios also claim that it had a New York office and directed interested buyers to the underwriter's New York office as well?
And although we're past the red light, I'm going to let you answer her question.
Thank you, Your Honor. None of those contacts, not a single one of them, has anything to do with the foreign merger on which their breach of contract claim is based. None of those contacts are related. Issuance of stock 12 years before, it has
So your argument isn't that there aren't New York contacts, it's that there's not a sufficient nexus between those contacts and this particular cause of action.
That's exactly right, Your Honor. This case does not arise, the breach of contract does not arise out of a New York transaction in any way. And for that reason, we respectfully submit that Justice Crane was correct in dismissing the case, and we respectfully request that Your Honors affirm her. Thank you.
Counsel?
Thank you.
Maybe we could just jump right to that. So what is, marshal for us the articulable nexus or the substantial relationship between their contacts and your cause of action?
And again, the standard is if it's in any way arguably connected. We have a breach of contract claim. Do not believe smoke and mirrors. Do not fall into that trap. We are suing for the dividends that were not paid. Counsel would have you believe we're suing for something else. We are the masters of our complaint. We would not be here if we weren't here for dividends. And going back to your question, I apologize, Your Honor. So what is the connection? What is the contact that is in some way arguably connected? We are suing on a breach of the certificate of designations, which, by the way, in response to your question, does say that payment is going to be made at 5 p.m. New York time to the paying agent, which is in New York. We have a New York contract that was formed when the defendants offered shares through New York underwriters with a New York choice of law on the New York Stock Exchange. That contract required as a place of performance that defendants pay the dividends to New York. There is no doubt that the plain and simple language requires dividends to be paid in New York. The Second Circuit has held that if you have a contract that is formed in New York to be performed in New York and breached in New York, that jurisdiction under the New York law is appropriate.
So we go back to whether this lawsuit, as you say, is a breach of the contract, or, as your friend says, it's based on the acquisition.
Yes, and it's
So
certainly a breach of contract. We are the masters
The way
of
I
our
see
claim.
it is the acquisition upended the the payment of the dividends, which is a breach of the contract, is what you're saying.
Yes, the acquisition triggered the payment of the breach of the dividends. It was the condition precedent. It was a mandatory condition precedent that you pay the dividends if you want to do an acquisition.
Thank you.
Thank you, Your Honors.
Thank you. Doe versus Combs. Justice Chan is recused on this case. If there is a tie, we will vouch in a fifth judge. You may proceed.
Thank you. May it please the court, Jeremy Hellman for the appellants. It is our contention that Judge Getz, by disallowing our clients from proceeding as John Doe's, abused his discretion.
You said he abused his discretion?
Abused his discretion. Although it is just an abuse of discretion standard, it is so clear that our clients should be entitled to this basic relief. And I call it basic relief, although it's a big deal. It's it's not going to be something.
Right, because you're trying to override a presumption of openness,
Absolutely.
right? Of the courts.
Right.
Where anyone can come in and everything's open.
Right. However, when we're dealing with a situation as severe as this, and we're not just talking about one person or two people or three people, we're talking about multiple people, not just my clients, multiple people with the similar allegations against someone who's so powerful, so famous, it's just impossible for them to proceed. I mean, that's the whole reason why the look-back window of the Gender Motivated Violence Act was created, was to enable people like my clients to come forward and go against someone that previously they wouldn't.
So here's my question. To the extent that counsel for the plaintiffs has appeared on television and in the media to talk about the details of the case, does that affect the application of the plaintiffs to go forward anonymously?
Well, the facts of the matter are very clearly described already inside of the complaints.
Yes.
The complaints are not just basic boilerplate complaints.
Agreed.
We have all the facts there already. So the notion that we went and did something on TV, that's actually something that was already known anyway in the public record, but more so, what was the point?
Well, there's a difference between something being in a clerk's file in the county clerk's office or in the e-file system, one of thousands of cases in the e-file system, and it's another matter to shine a light on the case and call the public's attention to it.
We want to shine the light on it. The whole point is that just as
So
my
what do you deal with the argument on the other side that you're trying to have your cake and eat it too? You want publicity so that the firm can go out there and I got this case. And at the same time, you want to shield your clients from whatever defenses that the defense wants to move forward with.
Well, that's only because the whole purpose is to enable other people to do similarly. And this isn't a situation of, well, who knows, there wouldn't be anybody else. There have been so many other people that have come forward. We have three people just ourselves.
And in that vein, counsel, the fact that the federal courts have not permitted this shielding on similar cases, how does that weigh into your argument?
Well, that's not helpful. However, I would say that our facts are so severe, and I can't speak to exactly what the facts are in every federal case, but I can speak to all three of our clients who very clearly described in their complaints exactly what happened to them, that they were drugged, that they were sodomized while they were barely even conscious.
In terms of your basis for this and the affidavit that your clients put in, all of the affidavits were very generic and similar in format. The only difference in terms of the words was the place.
Right.
How does that weigh into your argument in terms of the severity and the specific basis for each individual client needing to be anonymous?
Well, on the one hand, the same thing happened to all three of them, but it's because the complaints are sufficient. Even without having the affirmation at all, the complaint in of itself was sufficient, pursuant to the Doe v. Yeshiva case that talks about how even if an attorney affirmation is all that you have, so if an attorney affirmation is enough, and the attorney obviously has no direct knowledge, why wouldn't a complaint that is well pled and tells exactly what happened in the whole story, that should definitely be adequate. And these facts are so horrendous and so severe that our clients should have been entitled to this relief.
Thank you. You'll have time on rebuttal.
Good afternoon, Your Honors. Mark Kukro from Shore Tremonti for the respondents. So as my colleague here noted, abuse of discretion is in fact the standard. They have come nowhere close to meeting that. The lower court correctly applied New York law, under which the default is that a party has to proceed in its own name.
Well, there's abuse of discretion that is an error of law we must correct. And then we have the power to find that there's an improvident exercise, that maybe it wasn't an abuse, but nevertheless, there's a better outcome in this case, right? We do have that power, although it's not one we exercise often.
I think that may be correct, Your Honor. I think regardless of which standard is applied, the lower court did act correctly and in accordance with New York law, and I think reached the only conclusion.
Utilize our inherent power.
Excuse me, Your Honor?
Why should we not exercise our inherent power to grant plaintiff's application, perhaps for a time, while the case gets discovery, et cetera?
Well,
cases last a long time.
That's true, Your
And
Honor.
we would be, there's no question that these cases will generate fodder for public discourse. Hopefully that's all it is discourse and not violent actions and targeting of these complainants. So why would it not be certainly within our province to grant it at least until discovery is done and maybe summary judgment motions are entertained?
I think that would be completely contrary to this court's precedents. So if you look at the anonymous versus anonymous case, the Lerner case, the Twersky case, this court time and again has said that exceptions to the requirement that parties have to proceed in their own name are only applied sparingly and on evidence of specific harm unique to a particular plaintiff from disclosure itself.
I want to approach this from from the perspective of prejudice. So to the extent that the names of the plaintiffs have already been disclosed to the defendant, and to the extent that a great deal of the information at issue is within the realm of the defendant, how is there any prejudice evidence evinced by non-disclosure of their names?
Yes, Your Honor. So as a matter of fact, they have not yet disclosed their names to us. They have represented that they will, and I take them at their word that they will.
I thought that there was something in one of the briefs that said that they had disclosed.
They said that in their brief. As we noted in our brief, that is in fact incorrect. I think it was probably an honest mistake on their part, but they have not disclosed it to us. I take them at their word that they will, but even if they did, their motion sought to preclude us from revealing that name to any third party. That's obviously going to hinder our ability to investigate the case. Beyond witnesses that we know about, there's also unknown witnesses who may come forward in a celebrity case. The Second Circuit just recognized that as a significant form of potential prejudice in a case denying anonymity against these very same defendants.
Sex assault, sex abuse cases are necessarily going to be sensitive. This, though, on that spectrum the allegations seem to be particularly sensitive and particularly heinous, again, allegations as they are. Are these the type of allegations that almost per se or presumptively would make the plaintiffs, if their identities were revealed, the object of scorn or you see where I'm going with this question? That I appreciate that as I think Justice Michael indicated, the affidavits in support of their motion were fairly generic, didn't contain a lot of detail. But are these particularly heinous allegations of a nature that we should almost presume there's going to be harm to these plaintiffs if their names are revealed?
So, Your Honor, the answer to that is no, and that answer is found in this court's precedent in Twersky. That was a case that involved allegations that are even worse than the allegations that have been made here. That was the systematic, institutionalized sexual assault of dozens of children at a school.
I was on that case, and I don't know that I would say what you just said. Okay?
I understood that.
I'm sorry. No.
Well, in the Tversky case that did involve child sexual abuse and was brought under the Child Sexual Abuse Act, this court nevertheless found that a generic attorney affirmation that just said in unspecified terms that these plaintiffs are going to suffer
What about the term?
harms, that's not enough.
What about what's in the complaint, as your adversary argued? Is that not enough for us to rest our decision on?
It's not, Your Honor, because he's conflating two different things. He's saying that, oh, well, because the allegations are of serious conduct, therefore we should get anonymity. That is not the factual showing that you need to make to show anonymity. You need to show specific individualized harms from disclosure itself, not that what happened to you was a bad thing. What happened to you is always going to be a bad thing in sexual abuse cases. There is not a default rule in New York courts that sexual abuse cases are proceed anonymously. They usually don't.
Thank you.
I would just add that.
So, counsel, I had a question regarding if we keep it anonymous, is it the case, as your adversary said, that they will not have the names and won't be able to give those names to third parties, such as investigators, such in that regard, and how that might play into prejudice finding?
We did not ask for that relief.
sorry?
We did not ask for that. The only relief that we asked
You
for.
also said that you gave the names.
I,
And I'm sorry, we all read the same thing. So I don't appreciate that.
Is my office's understanding that we did? If we didn't, then we're
It's
gonna.
your honest understanding that you did. This is a big deal. You're in this court fighting this issue. So I do not appreciate that you were not honest with this court about the central issue.
I'm sorry.
That makes a difference for us.
It is our office's practice to do so, so I can't understand why that wouldn't have happened here. But I would add that the prejudice is, there is no prejudice here, as we didn't ask that the defense shouldn't be able to even say our names to anybody. We just asked that it shouldn't be filed with the court, and the court docket should have it as doe. So that's all that we're asking for.
With respect to a search for witnesses, for example, the names could be used or could not be used?
I don't see why they couldn't be used. We're not asking for complete anonymity. They should never utter their names. We understand that there's, of course, reasons why he would have to discuss it with people and everything. There's the request that we requested was very specific and limited.
Sir, did you need to make, I think the word your friend used was particularized showing as to each of the three John Doe plaintiffs?
With regard to whether having the name out there would cause a dangerous situation for them.
So the allegations in the complaint are so severe that it's understood what exactly the level of
But that's not the question. The question is whether, in order to defeat this presumption of openness, understanding that it is a presumption, that you have to make a specific showing that keeping it anonymous is going to, without doing that, is going to cause some danger or harm to your client.
So I'd maintain that just looking at those allegations is enough, because that's within the ken of even anyone to understand how severe and how difficult it would be for someone to have those kinds of allegations.
That would be the case with every sexual assault case, right? And we don't keep the names anonymous with every case. We keep the names anonymous and we defeat that presumption when there is a basis to do so, and a specific showing of a basis to do so.
This isn't just any other sexual assault. This is a sexual assault against someone who has power and fame, and there are many, 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 many people that would take issue with our clients and would seek them out, not just to necessarily harm them physically, but to harm them emotionally and to tell them one way or another their feelings about it. And our clients shouldn't have to be in that position.
Yeah, I understand that, but my question was, did you have to make some showing? So, for example, in the affidavit, did you have to put that in the affidavit as per our jurisprudence? That's really all I'm asking.
I would maintain that it wouldn't have to be specific in that light. It's understood just based on what's going on.
Okay.
The facts can show it out.
Thank you. Napolitano versus Bounce 21 LLC.
Good afternoon, Your Honors.
Good afternoon.
May it please the court, Simon Ramon for Plaintiff Appellant. This court has already reviewed the essential allegations with respect to the arrangement at issue in this case in the prior appellate review of the motion to dismiss. And essentially nothing has changed. The court already determined, it's now law of the case, that the arrangement the plaintiff described in the complaint, namely, he was not a member of New Lounge, he was not a member of the Bounce 21 entities, he was not performing oversight, he was not serving alcohol, he was not listed in terms of doing anything on day-to-day operations. And this court held that the defendants failed to show that that arrangement, and he, again, in the complaint, he acknowledged he was entitled under the arrangement that he would receive a percentage of the profits. And under that arrangement, this court held that that was not, as a matter of law, illegal and in violation of the alcoholic beverage, the ABC section at issue, 126 sub 1. Nothing has changed. All the defendants have basically argued in their summary judgment motion was that plaintiff characterized that arrangement as him being an owner. However, the characterization of a lay person in terms of what that meant is not dispositive and should not have led to summary judgment. There are still issues of fact, and in order to viewing the plaintiff's testimony in the light that was most favorable to him, the lower court should have acknowledged that his characterization of being an owner or a silent partner was not anything different. He didn't testify as to having, again, didn't testify as to being involved in day-to-day operations, didn't testify as being a member of the LLCs, et cetera. And the last thing I just want to touch on, only because it was in the brief of the respondent, was that in the event that we prevail on the appeal, it would apply to all of the causes of action as they were all addressed in the appellant's brief with respect to the issue of illegality.
So maybe this is an easy question. So the ABC at section 126 says that a person convicted of a felony is forbidden to traffic in alcoholic beverages, right? So to the extent that your clients stated, I'm an owner, how does that intersect?
Well, again, it doesn't change the fundamental arrangement, which is that, and this court has already held, it's law of the case at this point, which is that him receiving a percentage of the profits from the Bounce 21 entities, which they're receiving from the New Lounge, that in of itself does not make him a trafficker of alcohol as a matter of law that would lead to a summary judgment. And again, we'll rest on a brief with respect to, they failed to address, or I should say the lower court, I apologize, failed to address, even if he was considered to be an owner, and even if this was an illegal situation, the lower court failed to go through the proper factors in determining whether or not, because this was a malum prohibitum statute, whether or not it should be applied in this case. Thank you.
You may proceed.
May it please the court, my name is Mark Alonso of Alonso and Thatcher. I'm here arguing that Judge Frank's dismissal of Mr. Napolitano's complaint should stand. And the reason is because when we came here before, not this lawyer, but his other three lawyers had concocted the idea, well, he's a consultant, and that's how he can evade the SLA's restriction on a convicted felon receiving a share of the profits of a liquor license establishment.
But you didn't appeal our earlier case, right?
Pardon?
You didn't appeal our earlier case.
Yeah, and you sustained it. And you actually gave guidance, well, this court gave guidance, saying, well, okay, if he's—
I'm sorry, I've got it backwards. So we said that the defendants have not shown that the alleged consulting agreement with Napolitano, which did not involve his managing the business of serving alcohol, is violative of the statute.
Correct.
Right?
Yes.
And what are you saying now?
Well, what happened is we went back because I strongly believed that that was the case, and this was just a theory that was
What was the
concocted.
case?
That he was an owner, that he had gone in with the intent to evade.
So wait a minute, is there a contract that created an ownership interest, or was he just an investor that gave this company $100,000?
Neither.
Neither.
No, there was no proof in the deposition. He says,
So
I have no proof of giving you any money. I was just cutting myself in for 25%.
But you can't cut yourself in if you didn't give any money, right?
Well, but there are
I
services.
can't imagine that the owners of Bounce said, hello, Mr. Napolitano, I like your face, I'm gonna give you 20%.
No, they gave.
No, right? So he had to have done something, given something.
No, he provided services as a promoter, manager, not owner. You don't get to ride.
Not a bartender.
Not a bartender, no. But
He didn't
that's not
schlep
the-
drinks.
No, he was not bussing tables. did
Okay,
not actually
so how is it that that equals trafficking in alcohol?
Because this court has noted many cases from the SLA and elsewhere that show where you have malum prohibitum, you then go, well, what was the intent? And what's the intent of the law? And what's the intent of the people trying to evade it? And there are cases. I can point to the Potter case, which was a married woman whose husband left her with a bar. And over more than a decade, there was someone helping her. They developed a relationship. The SLA claimed that was availing. And this court, I think it was this court.
But what facts have been established?
That was not to be found to be, that is when you were.
Counsel, during the course of this case, while it was before the trial court, what facts have been established that change where we were when the case was first here?
And he plainly admitted that he was not a consultant, an independent contractor getting paid for the
But did
work
he, are there any facts that establish that he was an owner?
Yeah, no, none that show it other than his statements that I was an owner. I expected 25%. And he says it repeatedly.
I don't understand you because didn't you just say a few minutes ago that I was involved in the earlier case?
Right.
But we didn't rule for you, we ruled for them, did we?
Yes, and gave us our instruction.
And then I said to you, did you appeal our earlier case? And you said no.
No, I followed your instruction. It was a motion to dismiss, which sent us to discovery. So I decided to probe into the issue of the consulting agreement. Was it a one-off? Did you do a party? Were you the guy who handled reunion bars or March Madness events? No. He said, I was an owner. I was along for 25%. And there are many instances where you get a percentage, and it is not illegal, sufficient to void an oral agreement. For instance, landlords routinely, in the city of New York even, has leases with establishments that sell liquor. And if you hit a certain threshold, the city is not on the liquor license, but they get a percentage. But there is no inherent illegality because nobody's trying to evade the liquor laws. In this case, Mr. Napolitano has testified to multiple establishments where he says, I knew what the law was. I'm not allowed to be on a liquor license. And that's why I couldn't be on
And he
paper.
wasn't on a liquor license.
But that's what's wrong. For 40 years, I have sat there with clients and said, yeah, you're never going to pass SLA muster. If this court simply says, let's just call it a consulting agreement, there is no point to having the SLA look at applications because anybody problematic will simply never apply. If he had applied.
To be clear, this court didn't call it a consulting agreement. The parties did.
No, the
So
plaintiff.
So we didn't pull it out of the sky.
And that's why I.
Okay, so
that's
I mean,
why
you
I went
said
into this.
this court said what the parties said.
Right, but
Okay.
the parties being the plaintiff, and that's
Thank
why
you.
in discovery. Thank you, you understand. Thank you, Your Honor.
Just to address that last point, Your Honor, it wasn't just plaintiff that called this a consulting agreement. The defendants called it a consulting agreement in their papers. Paragraph 1 of their statement of material facts alleges that plaintiff was performing consulting services. They put it in their
Your
memorandum of law.
adversary just said that the plaintiff didn't provide anything in exchange for receiving profits. Is that your understanding of the nature of the consulting agreement?
No, that's not at all. He alleged and he testified to having provided capital. I agree there was some vagueness, but I just want to be clear. At this posture,
the summary judgment was granted solely based upon the doctrine of illegality. It had nothing to do with the fact that plaintiff had failed to show that he contributed, and that was not the basis of the dismissal.
So it's still not clear. Did he pay $125,000 or not?
At a minimum, there'd be an issue of fact. Obviously, our position is yes, he did.
What about the argument that he said he was an owner throughout the course of discovery? Is that accurate?
Well, again, it's viewing that testimony in the light that's most favorable to the plaintiff. It was merely his characterization of this arrangement that this court has already said was not per se illegal. And even if it was, it would not be something that...
Well, what this court discussed was the consulting agreement, not the fact that he was, holding himself out as an owner.
Yes, but our point is that both parties, the defendants alleged in their statement of material facts that the plaintiff was acting as a consultant. They're not disputing that he was providing consulting services. They're not saying that, no, what he testified to as far as consulting, that wasn't happening. In fact, counsel just now conceded that he was not an owner. He said, no, he wasn't an owner, he was a consultant.
Is the key question whether or not he was involved in the day-to-day operations of the company? Is that the crux?
No, because I think if this court, under the Lizardo's case, would say that even there, where the plaintiff had many more day-to-day operations and interactions in terms of the ongoing thing, even there, illegality should not be held to be a bar to recovery.
ABC Law 126 prohibits convicted felons from trafficking.
Correct.
That's the word. So what does the statute mean when it says trafficking?
Well,
in alcoholic beverages?
I think that presumably if you're obviously apply for and get a liquor license, that would be a violation. Or if you're, again, serving, pouring, engaged in the day-to-day operations, that would be probably a fairly self-evident violation. But in this case, where you have multiple entities in the way, there's no testimony that he's involved in day-to-day operations. There's no testimony that he's actually doing anything in terms of trafficking personally. It's not clear at all that the purpose of the statute would be served by denying illegality when, again, as this court noted in that prior decision, other defendants in this case were also barred from obtaining a liquor license. They would be the only people who would benefit from this. If you were to say plaintiff can't recover here, all the money, and again, this is not an ongoing business. Defendants admitted in their motion papers that the business is shut down. So it's just a matter of who gets to keep the money at this point. Is plaintiff allowed to sue as a matter of breach of contract, or defendants, who again, also some of whom are convicted felons, are they allowed to keep all the money and say, no, we're going to use this as a shield, or I'm sorry, as a sword, and not as a shield for the public good?
Thank you.
Thank you.
No, that is not allowed.
Thank you, Your Honor. Have a nice day.
Thank you. Have a great day. People versus Sandra Tavaris. You may proceed.
Thank you, Your Honors. May it please the Court, Matthew Vasilakos from the law firm Davis Polk, and I appear as pro bono counsel alongside the Office of Appellate Defenders on behalf of Ms. Sandra Tavaris. The trial court committed two reversible errors which prevented Ms. Tavaris from getting the fair trial she deserved. First, it is clear that the jury heard and understood Spanish audio from the prosecution's key video evidence that was not translated during trial. The trial court failed to instruct jurors to disregard their own understanding of the untranslated audio. Second, the trial court failed to charge the jury on self-defense, even though the factual record supported such a charge.
What in the factual record supports a justification charge?
Well, Your Honor, there's a few things in the record.
Given the video that we've all watched.
Yes, Your Honor. I think that the record supports that there was a history of threats made by Ms. Chandler against the defendants, including violent threats. They were verbal threats, but
None of them were ever physical. So there is no foundation for Ms. Tavaris to believe that there was going to be a physical altercation. These people could not stand each other and were at each other's throats for a very long time. Agreed?
I agree, Your Honor.
Right.
And I think that's...
So again, going back to my colleague's question, our law on justification is very clear. If you hit someone, if someone is hit first, you cannot avail yourself of justification.
Well, I think, Your Honor, two things. One is the law in New York requires a self-defense charge when the factual record viewed in the light most favorable to the defendant supports such a charge. So on the law side, we have to look at this in the light most favorable to the defendant. But then
Right,
looking
so
at
that's the question that I started with. If we look at the law in the light most favorable to your client who's laying in wait in a corridor for the victim, how does that support a charge of justification?
Well, I think it's a few things in the record, Your Honor. First, you have the history of conduct from Ms. Chandler, the verbal threats. But then looking at the video itself and the altercation, Ms. Tavaris' situation was very different from her co-defendants, her husband's. She was videotaping the fight. We see Ms. Chandler walk into the stairwell.
Well, no, she opened the door and beckoned the victim to come in.
Yes, but Ms. Tavaris herself wasn't initially involved in the altercation. We see that her husband and Ms. Chandler are involved in the fight. Throughout the video that we watched,
Well, it's not necessarily a fight. It's once she lured her in, beckoned her to come in, the husband takes out a pipe and hits her over the head with the pipe.
well, I don't think ever a pipe was said or in the record, Your Honor. But
An object.
An object.
Video.
I'm sorry?
Video.
It's just what my eyes saw.
I think the video shows a black plastic bag that is taken out by Mr. Almonte. But in any
He hit the victim with a black plastic bag.
something inside that bag, Your Honor.
Oh, okay.
Yes. So we all saw the video. We all saw the video shows, but we're talking about Ms. Tavaris here, who on the video record is not seen.
Look, we can't separate these two.
Well, I think you can.
No, it was clear that the wife is assisting the husband. It's clear she knows what's coming, and she lures this woman into the stairwell.
Well,
And the moment the woman puts her head in there, her husband hits her.
Well, I think, Your Honor, it's important to consider that the jury itself asked the judge for instruction on self-defense. They sent a note to the judge asking how to consider self-defense in this context.
Right, and when the judge asked the lawyers whether she should give a charge, they all said no.
Well, so, Your Honor, on the self-defense charge during deliberations, I think it's an improper time for a charge on self-defense to be given to the jury.
So then what does it matter that they asked about it? What's the import of it? If there was a way to resolve it and your client didn't avail herself of that, what does it matter?
Well, I think it matters, Your Honor, because the request for justification defense was made when they were discussing charges to the jury before summations were made. That charge was not given by the judge. Then it becomes clear that the jury is thinking about self-defense during deliberations. So
The fact that they're thinking about it doesn't mean it's correct. They obviously don't know what the standard of law is, and that it did not apply in this circumstance.
Well, Your Honor, I think that's the exact problem here, is that the fact that the jury asked the question
No,
about
the fact that the
self-defense-
jury asked is not an implication that that is what was required, right? I'm sure that the defendant's counsel, who was allowed and permitted to articulate that during his summation, is why the jury asked the question. So he did a very good job. That doesn't make it appropriate.
Well, Your Honor, what I'm trying to say is that when you look at the law, and the law says to look at the facts in the lights most favorable to the defendant, and then the jury asks about self-defense, to me, that suggests that the jury was considering there might be facts to consider self-defense in the I say I'm out of your time, Your Honor. I didn't get a chance to adjust the translation, but perhaps on rebuttal.
We'll get to that on rebuttal.
Thank you.
Okay. You may proceed, counsel.
Thank you. Good afternoon. Assistant District Attorney David Crowley for respondent. I think on the issue of justification, as this court has previously found, there was no reasonable view of the evidence that would support the charge in this case.
Let me play devil's advocate. As I said earlier, these parties couldn't stand each other, and they had been bickering and arguing. The police had been called multiple times, right? And there had never been a physical altercation. So although my last question suggested that the wife had to have known that the husband was going to hit her, what evidence is there of that? In light of the fact that there had never been a physical altercation, why should we assume that she knew that?
I think, if I understand Your Honor's question correctly, that would go to the weight of the evidence of the wife's guilt on accessorial liability, which I don't understand to be the claim they're raising.
Okay.
Because she was held guilty as an accessory, right? The question were the two of them entitled to the justification charge based on Mr. Almonte's abrupt strike when Ms. Chandler just walked in there with her bag, holding her phone, just filming them without any threats. So, I mean, I could go into all the reasons why I think on this particular
Well,
record.
your adversary suggested that in light of the jury's note about self-defense, that perhaps the jury thought that at least the wife may have been entitled to that.
Well, I don't know that their note said anything about wife versus husband. I do think Your Honor was correct in saying the jury's asking about it because it hasn't had the benefit of the instruction. And I think somebody who appreciated the fact that maybe the defense was better off with them operating in ignorance was defendant's counsel. Because when the court offered to instruct the jury in response to the note, counsel said, nope.
Declined.
I'm very satisfied with the way the court handled this, which I think is clear evidence that the defense did not want the court to issue the instruction.
Because had that instruction been given to the jury at that point, they would have learned that someone who strikes first is not entitled to the self-defense.
That's correct.
Justification.
And that also there would have had to have been both a subjective and evidence of both a subjective and objective reasonable belief that force was necessary. And again, there was nothing to suggest that force was necessary for these two to defend themselves, as this court, of course, has previously found on the co-defendants.
Counsel, what about the jury note and the judge not just directly telling the jurors that if something is not in evidence, the information that they're asking for is not in evidence and therefore they cannot consider it?
So I think the first time the judge broached this with the jurors was during voir dire, when I believe in front of both panels, jurors had disclosed that they spoke Spanish, and the court elicited from a number of them.
What happens in voir dire is worlds away from what happens in the deliberation room. So let's get to the note and the judge's response to the note.
Correct. So it's worlds away, except that we now know, we have a pretty good understanding of why the jurors submitted the note, right? So they some number of them, hear this term, Fotolasa, which I'm sure I'm mispronouncing, and they issue this note saying several of us can understand this. But then they ask for court translation, which I think implicit in the question, in the request, is their understanding that they are not supposed to go ahead.
My question to you is, why is it not improper for the judge to have just directly said, that's not in evidence, you are not to consider that?
Well, I think the judge, in context, the instruction does say that, right? So the judge says,
well, one of the things, she discussed it with the parties, right? The response?
Yes, she discusses it with the parties. First, Mr. Almonte's counsel says, that's not in evidence, it shouldn't be translated. Then Ms. Tavaris' counsel says something to the effect of, I agree, they should be told to disregard it. And the prosecutor also agrees and says, as much as I'd love it, they can't use their special terms. And so at that point, the court says, all right, then I'll tell them it can't be translated. And Ms. Tavaris' counsel says, yeah, and yeah, right? Indicating that he is satisfied with that.
There is no objection.
There was no objection, not at the point that the court previews its instruction, nor after the court actually reads it, which would be a perfect time if more was required, or if defense believed more was required to have said it. But then the court doesn't just say, and this is me finally getting to your Honor's question, doesn't just say, no, I'm not translating it. The court says, so the only thing I can tell you is that you have to decide this case on the evidence that came in a trial. That, she had just read the note, so the phrase, was not obviously translated, so I can't give you a translation now after everyone is arrested and I've instructed you. I can't do that. You can only judge the case and make your opinion on what has been in evidence, and everything that has been in evidence has been given to you. I submit that what the court is trying to articulate is exactly what Your Honor said, and that is what this court found on Mr. Almonte's appeal.
So you know that I was on the Almonte case?
I do.
All right.
Yes, yes.
And when the judge said that, there was no objection by either party, was there?
There was no objection by either party, correct.
Thank you.
Thank you.
Thank you, Your Honors. Very quickly on self-defense, I'll say that Ms. Tavaris is entitled to her own charge. Intent and her involvement in the altercation is its own, she's her own co-defendant.
So granted, of course we believe that. Yes. How could we possibly disagree with that? What about the fact that her counsel said, I would just say that I am very satisfied with how the court addressed this, referencing the whole issue of a justification charge, and she did not join in Mr. Almonte's request for a justification charge?
Well, Your Honor, I think, again, going back to when this was offered during jury deliberations rather than after summation. So the counsel did not have a chance to prepare his argument on how the jury was going to be instructed. Also, just to clarify the record, Ms. Tavaris' counsel did join the justification request. You'll see in the record there, Mr. Almonte's counsel made the argument for a justification defense. Ms. Tavaris' counsel does join that and then makes subsequent argument for why justification defense should be granted. So I think there is evidence in the record
At the first,
before the jury was charged.
Right.
Yes, exactly.
but when it was offered.
It was offered too late.
In response to the jury note,
Yes.
seeing as defense counsel raised the entire issue on summation, said, no, it's okay, I don't want that.
Your Honor, again, I think it's too late at that point. It's after
No,
summation.
it's not.
Jury's
If,
already
if you
deliberating.
think justification defense is a viable defense, whenever you get it, that's a prize. If you believe that that is a viable defense, whether you get it right at the charge or later on before the jury, so long as they get it before the jury reaches a verdict, they have the benefit of the information.
Well, Your Honor, charging a jury on self-defense requires a number of elements for the jury to consider.
Oh, I know, I used to do it.
Yes. So to give that to the jury without giving the counsel the opportunity to present on summation how the facts fit into those elements, I think it's just unfair to trial counsel.
Again, the summation I read did that. But I want to thank you for your pro bono service. You did an incredible job on the hot fire questioning by this court. We appreciate you and we appreciate the society.
Thank you, Your Honor.
Thank you. Martin versus Poe Affiliates.
Good afternoon, Your Honors.
Good afternoon.
Gregory Lewis for the appellant, from the law offices of Shab Katarachi, for both appellants, Poe Affiliates and Sure Management. As the court is well aware, our position is that the lower court erred in not granting our motion for summary judgment to dismiss the case based upon the workers' compensation bar, inasmuch as the plaintiff was employed by William Sure, who was the sole
What
owner.
evidence is there that these companies operate as one?
Well,
and that they are not fully taking advantage of their separate and distinct legal and corporate identities?
Well, the fact that Poe Affiliates has absolutely no employees, and we have the affidavit of William Sure indicating that he made all of the major management decisions for Poe Affiliates, and he was the sole owner of SMCGC Contracting, shows that Poe Affiliates really did not have any independent function outside of the ownership. So it is.
My question was whether there was any evidence that there was that they are distinct legal entities.
Well,
They file separate taxes, right?
yes.
Okay. And do they observe separate corporate form?
My understanding is that, again, as I indicated before, Mr. Sure makes all of the major.
No, I read the record. I understand. And so I get it.
So again, while
But
they
he's trying to get around the labor law through corporate structure.
well, I don't think.
And you still have to provide your workers a safe workplace. And you have to provide them with proper equipment to do the job that you give them to do.
Well,
and this gentleman was given an unsecured ladder to work on.
Well, we're not contesting that. He was not given an unsecured, well, all right. I'm sorry, I didn't mean it that way. The ladder was not secured by one of his coworkers for whatever reasons.
And that's a requirement by the owner and the GC to make sure that if you ask a worker to get on a ladder, that the ladder is either secured or that you have another person who's holding that ladder, especially where this person is being asked to do ductwork from the
Well,
ceiling?
well, again, the entity that was in charge of doing the work there was the general contractor, who was not sued, okay? Could not sue them because he was the sole
worked
owner.
for him,
He worked for them, okay? So then we go to the other entities that were sued. We have the management company, and I believe that the case law is clear that
Said this management company hired the GC, so that makes him an agent of the owner.
not if they did not.
Yeah, that makes him an agent of the owner, because Poe doesn't have any money undergirding his connection to the building, does he?
I'm sorry. Would you?
He doesn't own the building.
Are you talking about just Mr. Scher, or are you talking about the corporate entity?
Mr. Scher.
Well, Mr. Scher is one of the owners, but he's not the sole owner of the building.
I understand it's like a minutia of percentage.
Yes.
Am I correct?
That's true.
Okay.
But again, he's still an owner, and there's none of the cases say that there's a distinction between the percentage of ownership that the owner has. They are owner. He is an owner. And in this particular case,
And as an owner, he has to provide a safe workplace for his workers. We keep going back to the same thing, because this change in corporate structure doesn't change that obligation under the
well, I
labor
believe
law.
that the Durag case addresses that issue, in as much as they're not, if the corporate entity, the ownership entity, has no real involvement in the day-to-day operations, and we have Mr. Scher here.
No. Are you saying that the owner of the building, if he does not involve himself in the day-to-day operation? Let me finish my statement.
I'm sorry.
If a owner of a building doesn't involve himself in the day-to-day operations of that building, somehow that lets him escape liability under 240 sub 1? That's your argument?
No. My argument is that in this particular case, the company that was owned by Mr. Scher, okay, that he was an employee of, all right, they were responsible for making sure that he was provided with the proper
Safety
equipment.
devices?
I'm sorry?
Safety devices?
Yes, okay, true, yes. In this particular case, as I indicated before, Scher Management, even though they were the party that retained SMG to do the work, they did not have any control over the way the work was done.
He retained himself. He owns the company. What are we talking about here? But you'll have time on rebuttal.
Thank you. Good afternoon. My name is Stuart Diamond. I'm here on behalf of the plaintiffs' respondents.
Counsel, please have a seat. Thank you. Go ahead.
Thank you. In opposition to our motion and in support of their motion, defendants established or demonstrated nothing more than that there was some commonality of ownership and some commonality of officers among the three corporations. We cited case law below in our brief that that's not enough. This court said in Kalenovich v. 56 Realty that the two entities have a principle in common is insufficient to establish that they were alter egos. That's all that they showed. Counsel mentioned today, the first words out of his mouth was that plaintiff was employed by William Scher. Plaintiff was not employed by William Scher. Plaintiff was employed by a corporation. It's kind of hard to address the evidence in this case because there were no citations in either brief to a single page in the record. But I'm assuming that most of the allegations came from Mr. Scher's affidavit since he wasn't deposed as in this case. He said, I control, not controlled, control at the time of this affidavit, all major decisions related to Poe affiliates. He didn't say anything about controlling the decisions of the other corporations. We cited the case law that said that mere commonality of ownership or officers or principals is insufficient. We cited, we addressed all of the cases they cited in their brief. All but two were a situation where the actual owner of the property was the defendant, who was a principal of the corporate employer. That's not the case here. There was none of the corporations were involved directly in the employer. The mere commonality of Mr. Scher among these corporations is insufficient. Thank you.
Question. Don't
She has
go
a
away.
question. She has a question.
Thank you. So, Mr. Scher, in his, I think it's affidavit, said that neither Poe nor Scher gave the plaintiff instructions, nor did they give safety instructions to SMCGC. How is that dispositive with respect to workers' comp exclusivity or the issue of being a statutory agent?
Well, for Poe, they were the property owner, so it's not even a question of there being an agent. They're liable regardless of notice, regardless of control. They're liable, absolutely liable under Labor Law 240. On the issue of Scher management, and this goes to their second argument, we cited the testimony of the vice president of Scher management, Mr. Caulfield. He was the witness who did testify for the defendants. And he said that the company operated, managed, and maintained the building. That company, the property manager, hired Mr. Martin's employer. And Mr. Caulfield also said that he hired the employer, he himself, to do renovation work, including the work in Suite 507 that Mr. Martin was doing at the time of the accident. And finally, Mr. Caulfield testified at his deposition that the company managed the building. He, Mr. Caulfield, gave day-to-day direction about the work, this construction work on the site, and that he, Mr. Caulfield, delegated the work that Mr. Martins was doing to Mr. Martin's employer. He used the word delegated. That's his word, not mine.
Thank you.
Thank you.
Okay, yeah. Well, once again, I'm just going to go back to the case law that I cite, which, with regard to Scher management, the mere fact that they gave general supervisory or general instructions as to what work had to be done does not make them an agent on behalf of the owner. And I'm going to go back to what the Deride case said with regard to the fact that the two corporations, if one company, in this case, the owner, had no employment, if the company, the owner here, had no employees, the fact that they were an owner does not make them liable here, inasmuch as the plaintiff's employer, who was involved in this particular work, basically ran the ownership entity. And I believe that is the holding of Deride.
Thank you. Olympic Galleria versus SIT. You may.
Okay, may it please the court, Robert Kaplan representing appellant Jackie Sitt on this case's second visit to this court. The portion of the order appealed from should be reversed because the motion court misapplied this court's controlling authority concerning the entitlement to the recovery of attorney's fees, and the motion court, in trying to distinguish that controlling authority, misapprehended the facts of this case. This court has squarely ruled in both Sandar Associates and BN Realty Associates that when a landlord refuses a tenant's tender of rent and fails to obtain a court order permitting the acceptance of rent without prejudice, that landlord, even if it ultimately prevails in its action against the tenant, has waived the right to recover attorney's fees. That is exactly what happened here, and therefore those precedents should apply with full force here. It is undisputed that appellant tendered rent payments to respondent in both January 2023 and December 2023, and respondent rejected both of those payments. It's undisputed that respondent did not obtain a court order permitting it to accept payments of rent without prejudice. And it's undisputed that the rejection of these rent was not accidental. The respondent practically brags that it was, quote, carefully, close quote, monitoring its bank account to make sure that it could reject any payments by appellant. I note that this court, in its prior ruling in this case, held that respondent had waived any prejudgment interest because of its refusal of the rent tendered by appellant and its failure to obtain a court order permitting the acceptance of that rent without prejudice. The motion court got this issue right in its January 22nd, 2025 order, but then it got it wrong in its April 29th, 2025 order on respondent's motion for re-argument. The motion court, trying to distinguish Sandar, claimed that, well, in Sandar, the tenant wasn't in breach when the landlord refused the rent, but that wasn't the case here. The motion court was completely wrong. My client was not in breach. It's crystal. What had happened was the landlord attempted to terminate the respondent, the appellant's month-to-month lease in 2022, but reinstated it in December 22 by accepting the respondent's rent, the appellant's rent.
But don't you have what you were seeking? Isn't your client now deemed a month-to-month tenant?
Yes. So,
isn't that what you wanted?
Your Honor, in January, he was a month-to-month tenant, and he did exactly what he was supposed to do. He tendered the rent to the landlord. So he didn't breach anything. It's the facts are the same as in Sandar.
I'm not disagreeing with that. I'm saying to you, don't you have what you wanted? You have your no more use and occupancy is an issue. Your client is a month-to-month tenant and now owes all of that back rent that wasn't paid.
Yeah, it's been paid.
It's been paid now?
Yeah.
So are you asking that we dismiss the case?
I'm sorry?
Are you asking that we dismiss the appeal?
No. I'm not asking to dismiss the appeal because we're talking about the attorney's fees. That's the subject of this appeal.
If the month-to-month tenancy was recognized, why isn't the landlord entitled to attorney's fees?
Because he rejected the tender of rent, just like in Sandar and just like in Ave Realty Associates. So even if the landlord ultimately recovers against the tenant, the appropriate sanction for rejecting the rent is deny of attorney's fees. Also, as this court held in its ruling last year, also a sanction for not accepting the rent without getting a order permitting it to accept it without prejudice is denial of prejudgment interest. And that's what this court ruled then. Because of the landlord's conduct.
We'll have time on rebuttal.
Thank you, Your Honor.
For the respondent, Rosenberg and Estes by Bradley Silverbush. Good afternoon, Your Honors. I will answer Your Honor's question. He got exactly what he wanted. He got the case dismissed because we didn't serve a 6-month notice, so we had to start all over again. But this court did affirm 2 causes of action. The first cause of action for breach of contract because there was no rent paid for over a year prior to the commencement of this action, as well as an award of attorney's fees pursuant to the contract provision in the lease, which incidentally this court took judicial notice of in its decision. What counsel hasn't informed the court is last week the court below issued a subsequent order on his motion for renewal of the award of attorney's fees and denied it. And that's a change of circumstances that he should have brought to the court's attention. I'm bringing it to the court's attention. This issue has been heard twice, once by this court taking judicial notice, once by the court below.
And so, sir, what's the appropriate outcome on his appeal?
The appropriate outcome on this appeal?
This appeal.
Is that it be denied and that, as per Your Honor's prior order, that the court below determine the amount of fees to be awarded at a hearing, which this court has already directed. He could have sought further leave to appeal. He He did not. He did seek re-argument of this court's decision.
Denied.
And I think the record is clear. Thank you, Your Honors.
Thank you. You have a minute.
This court has never ruled on the April 29th, 2025 order. The court originally denied attorney's fees to the landlord, then it reversed itself, and this is the appeal from that order. This court has never had the opportunity to rule on this issue. That order we perfected our appeal from the January 22nd order in March of 2025. The order awarding attorney's fees to the landlord happened a month later. So that order has never been before this court before. It's never been adjudicated by this court.
What was the attorney's fee issue that we addressed in our September 11th, 2025 order?
There was no attorney's fees issue. It wasn't before this court. All this court did was say, oh, we see there's been a subsequent order, and if there's going to be if there's going to be a determination of what's owed to the landlord, this should be part of that hearing. But it didn't say, because at that time, this court had never ruled on whether or not the award of attorney's fees to the landlord was appropriate, because that order happened after our appeal was perfected.
Okay.
So it wasn't before this court.
Thank you. Woodward versus J.T. Megan and Company. You may proceed.
Good afternoon, Your Honors. May it please the court, Lisa Como for the plaintiff appellant. It's our position that the Supreme Court erred in concluding that the accident at issue here did not occur in a passageway. And to be somewhat Shakespearean, I would submit that a passageway by any other name is a defined walkway. It's some feature, some configuration of the workplace that requires the worker or guides the worker's steps in a particular way and in a particular direction. But even before that, I would also like to submit that just because the mezzanine, which we have called a hallway, whatever you want to call it, just because it's 12 feet wide does not mean that it's merely an open area and not a passageway. Here, as you know from the record, we have the doorway cutout that the plaintiff had to use. It was his only means of entering the mezzanine. There was a scaffold erected in front of it. He had to go through the doorway.
Like a maze.
It was, and he had to sort of duck under it. He's holding a box. My understanding from the record, the box might not have been particularly heavy, but I think it was large, and he mentioned, like having it in front of him. So I think that the defense would like to portray the area as him having like, oh, this wide open 6 feet of space, but in reality, there was a foot between the doorway, then there was the scaffold, he had to duck under it, and then it's 1 or 2 steps, and he's just unable to avoid tripping on the cutout. So we would submit that all of those things taken together, including the fact as well, I don't think you can factually separate him exiting the doorway from being in the passageway. I think probably there's nothing that says a passageway can't turn. He had to come through the doorway, immediately turn to his left, try to avoid the cutout, which would then be on his right, and proceed down his walking path.
As to the question of whether this is a passageway, the photographs aren't particularly helpful, are they? Because they were taken after the accident and after the scaffolding was removed?
That's true. They don't show like how little room he described having. However, they are somewhat helpful because it gives you the idea, and it's consistent with the blueprint of how the cutout, the inlay, how much. And I think Mr. Hackett from Megan said that it was 6 feet wide. So as we stated in our reply, when you do the math, if it's a 12-foot wide hallway and you're taking up 6 feet with some space left on either side, that's 3 feet. Then that's additionally taken up by another foot, another 12 to 18 inches of scaffolding. There's very little space, and so he really, I think he could not avoid stepping and tripping over this thing just for the very reason that this was not a wide open space where he could walk anywhere he wanted and have simply avoided it. I think that's the purpose of the passageway rule.
So the photos that were submitted there were photos with boards that were built up.
Yes.
Now, that looks like a passageway. Those weren't in existence at the time of the accident, correct?
I'm sorry, I'm not sure which photographs. I think the best photo, to my understanding, it's probably, sorry, I'm lost it now. And I had it tabbed too. I apologize, Your Honor. I think it's 1372. It's not great because they're a little bit dark, but you get the idea of the dimensions, and then you've got to picture a scaffold in place sort of on the right side of the photo as well. But the cutout was always where it was. There were differing things inside it at different times, but at the time of the accident, no one was working there. There was no reason that it could not have been protected in some fashion, either with a covering or something else, and in combination again with the scaffolding. I'd also very quickly like to mention, I think it's clear that the court was incorrect and mistaken in saying that the passageway 23-1.7E1 only applies when you trip on debris. That was one of the reasons stated in the court's order, but clearly by its own terms, the regulation refers to any other condition that could cause tripping.
Conditions or obstructions which could cause tripping hazard.
Exactly, and also as Mr. Woodward's foreman, Mr. Kerpis, from his employer Atlas, testified, this had been an ongoing problem. He had actually complained about it. He himself recognized it as a tripping hazard. The workers were having trouble coming in and out with that scaffolding there and with the other work going on and that cutout being right in front of them. So we would submit that this is in fact a passageway, and we ask the court to please reverse that aspect of the order appealed from, and even to go further and grant the plaintiff summary judgment under that regulation.
Thank you.
Thank you.
Good afternoon, Your Honors. Kevin Pollack from Fabiani Cohen and Hall on behalf of the defendants. It's submitted that the court below got it correct. The evidence indicates that the accident location was not a 23-1.7E1 passageway. The accident happened on the mezzanine level. That it's the entire mezzanine level is where the accident happened in one spot, but it's on the mezzanine level. The plaintiff himself said it was 200 to 300 feet long. On one end of this.
But that doesn't really matter, right? What matters is what he had to traverse, what the conditions were in traversing, and I gotta tell you, setting up a scaffold where right outside of a stairwell and the entry point into this area isn't exactly the best setup. I mean, if you've got workers who have to duck under a scaffold, and then 2 steps later, there's the inlay.
The plaintiff has his other claims against the defendant. The issue, the sole
That doesn't matter.
So the issue is whether or
If
not,
this one is a viable claim, why can't this one stand?
because it's not viable, this wasn't
Okay.
a passageway. The plaintiff himself testified that the accident happened at least 6 feet away. That's 6 feet away from the entrance to the mezzanine level. And
Based on the dimensions that were just described, do you take issue with the dimensions that your adversary described, that it was 12 feet wide?
it was the evidence was that it was 12 to 14 feet wide. The plaintiff himself said it was about 6 feet away from the entrance. That's the plaintiff's own testimony. And there was at least, he described it as several steps.
If this inlay was in the middle of the mezzanine, and it's going to be centered, which is aesthetically more pleasing, and I would imagine that that's what they're going to do, even at 14 feet, if you've got a 6 feet drop in the center, how much space we got on either end?
No, it's
It's math.
But there's no
It's
6 feet
math.
drop. There's no drop. I'm not sure where the drop comes into the issue of what.
This much is enough of a drop.
All right, but that doesn't determine whether or not there's a passageway or not. The inlay was part of the floor. It's part of this 14-foot wide mezzanine. That's what happened.
Isn't this a question of credibility? I mean, how can we decide a motion for summary judgment where the scaffold plays such an important part of determining whether this was a passageway or not?
Well, I'm not sure how it plays into whether it is or it isn't. I mean, the plaintiff says he's
If there's a scaffold and it effectively narrows the large cutout that we see in the photographs, to the point that it's the only way to go in, and we know that because it's a stairway, right? And it has a bar that workers have to duck under, and it is the only way to access the mezzanine floor, then there is a real question as to whether that's a passageway.
Well, again, the evidence is that the scaffold was 12 inches in depth. That's it, 12 inches. And the accident, plaintiff's own testimony.
And what in the record tells us exactly where the scaffold was located?
The plaintiff's testimony. He said there was about up to 12 inches of distance from the entrance to the scaffold. The scaffold width was only 12 inches.
Then he took 1-2 steps and
right, those 1-2 steps are around another 4 feet.
into the inlay.
Those 1 or 2 steps, if you do the math, and it's about 6 feet away, that's another 4 feet. I mean, it's a human step, so it could be 3, 4, 5 feet.
The narrowness of this area is not a surprise to you. Purpose had complained about it to Hackett, and then another, the vice supervisor, or Eric. So that's been known that other workers had complained about it, so that was an issue. So by saying, oh, it wasn't that wide, or oh, it was so wide, it was an issue that was known to Hackett, at least, that it was a tripping hazard.
Yeah, that may go to some other issue about negligence. It may go to an issue if there was a tripping hazard. It doesn't go to the issue whether or not there was a passageway and whether the accident happened in a passageway.
Well, viewing the evidence in the light most favorable to plaintiff vis-a-vis your motion, does a triable issue of fact exist as to whether the format of the mezzanine created a defined walkway used to traverse between discrete areas of the work site?
Based on the evidence, I don't think so. Again, the argument that the plaintiff cites some cases of this department where somebody tripped right at a doorway or as soon as walking into a room, a foot away, an inch away. This court has held that's a passageway. That's not what you have here. They raised that argument for the first time in appeal. They didn't raise that argument below. That's a new argument which you shouldn't consider to begin with. But if you do consider it, those cases say, yes, where the immediate area next to an entrance or a doorway, this court said is a passageway. Here you have 6 feet of distance. Those cases don't apply.
Where workers are walking down in an outdoor area and they've created a path and then drop stuff in the middle of the path, and we consider that a passageway with snow on either side. So a passageway is simply an area where workers have to traverse to get from point A to point B, and it seems to me that this was that. You ducked under the scaffold, you were on some piece of tiling, and just beyond that tiling was a dip.
Well, to answer your question with the red light on, please, if I may.
Yes, of course. I would never say something and then not let you respond.
This court has held that, again, as our position, this was an open area. And your point is that, well, he had to walk there.
Yeah.
And this court has said, in several cases we cite, Delana is one of them, that simply because you have to walk someplace doesn't make that a passageway. Maybe it makes it a work area.
I agree with that.
That's not the issue here. The issue is passageway, not work area.
All right.
And I think under E1, that location was not a passageway as a matter of law.
I got your argument.
Thank you, Your Honor.
Counsel, I'll hear you now.
Thank you. Just very briefly, I would like to acknowledge, and I do in my reply brief, we did not specifically cite the doorway cases below, but plaintiff has always made the same argument. Factually, the argument always was that because of the exit from the stairway, because of the presence of the scaffolding, which he had no choice but to duck under, because of the distance there, that his steps were guided in such a way that it qualified as a passageway. We do cite, doorway cases, and I think they're applicable because he said it was 1 or 2 steps. I don't see any material substantive difference between someone who crosses the threshold of a doorway and there's 1 step and they fall, or a person takes 1 step or maybe 2 steps.
What is the defining characteristic or characteristics of a quote-unquote passageway?
I would submit that it's something that, well, I guess in a way there's two. One is that it's a customary place that you walk, like the outdoor passageway that Judge Manzanet just mentioned. It can be a worn track, it can be that sort of thing, but it also is a defining feature of the workplace that's basically guiding your steps. It can be piles of materials on both sides. It doesn't have to just be a wall. It can be any number of things, really. It's features of the workplace that either require or make it habitual or necessary for the workers to walk in a certain fashion. And here, as I mentioned, I think the plaintiff had absolutely no choice. He had to duck under that scaffold, and he wanted to go to the left. There was really only one way that he could do that, and I submit that that is a passageway. And just very quickly to the 6 feet thing, I think it's a little confusing. At page 625 and 626 of the record, the plaintiff was asked how much space was there between the staircase exit and the cutout. Not any reference to scaffolding or anything like that. And he said, sort of like, well, a couple of paces, he said, a couple of paces. And then they tried to pin him down, well, what do you mean by a couple of paces? And he said, well, sort of like 6 feet. So that's where they're getting the 6 feet, but that doesn't take into account the presence of the obstruction and the scaffolding and everything else.
Thank you so
Thank you
much.
very much. Thank you.
328 8th Avenue Realty versus DHCR. Division of Housing, New York State Division of Housing.
Good afternoon, Your Honors. My name is Santo Galino, Horing, Welton, Rosen, DeGruge, PC, for the appellant, 382 8th Avenue. 1981, 1984, my client took a vacant SRO, single-room occupancy building that only had one communal bathroom per floor and created Class A apartments from scratch. The building required structural work. There's no dispute what the condition of the building was. None of that is in dispute. In 1984, when the C of O was issued, all the law stated was substantial rehabilitation entitles the landlord to an exemption. In 1992, this court defined substantial rehabilitation as restoration to former good quality, restoring the building to its former good quality. In 1984, shortly after the C of O was issued, the agency itself issued an operational bulletin, 84-4, where they said anything that, the exact words, will materially add to the value of the property or appreciably prolong its life is a substantial rehabilitation. Fast forward to the summer of 95, they reissued that same operational bulletin. And then in December of 95, they issue Operation Bulletin 95-2, where now they went from a qualitative standard, right? The standard clearly, this court recognized it in another case called Contos, also Eastern Pork and Contos. This court recognized the qualitative standard. The 84 Bulletin recognized the qualitative standard. And then in 1995, they came up with a quantitative standard. That's fine. You can do that. But you can't apply it retroactively. And I think now the Regina case makes clear, Regina Landgraf, the Thorpe case that we cite from the United States Supreme Court makes clear the presumption against retroactivity applies. It applied to administrative policy, and when they codified the 95 bulletin into the Rent Stabilization Code in the year 2000, it definitely applies there. There's a presumption against retroactivity.
Did your client apply for this exemption?
In response to an overcharge complaint in, I think, 2019 by a tenant in the building, he said, my building is exempt. We did this work. The agency said, oh, you have to file an application for an administrative determination, and then we'll decide if your building is
And isn't that the genesis of the whole problem, that the filing was so late in time that you didn't have all the documentation that you would need?
But the problem, the agency has always, there's been no requirement to file for administrative determination. Now, in fact, they went out of their way in the past year, I think it was.
But I'm looking at it a little differently. I'm looking at it from the perspective of not all rehabilitations qualify for an exemption from rent stabilization.
Right, that's true.
So to that extent, you have to have some documentation, and your documentation apparently was de minimis in the sense that you didn't have the necessary invoices and so on and so forth. And the architect was unable to quantify the amount of rehabilitation that was done.
I respectfully disagree with that. So you have a Department of Buildings file with the plans, with the permits, has an initial cost affidavit of $60,000 in the record, a final cost affidavit of $100,000 in the record. This is 1984. That was when that was real money in the record.
It's real money today.
It was more real back then. In terms of construction, that was a lot of money. You've got the original engineer who did the work passed away, unfortunately. Otherwise, we would have gotten something
Yeah,
from him.
but he would, go ahead.
DHCR asked for an engineer or architect's affidavit to go look at the file, inspect the building. They asked for that.
We know, but
provided
the
that.
issue was that I do not intend to throw that person under the bus, but his assessment does say it appears, was reported, and then in general says appears that the items appear to have been replaced.
Yeah, but
It appears isn't proof, is what we're saying.
Well, but
That's not, this was definitely replaced. This entire system was replaced, absolutely. That's not what it says, it said it appears.
Well,
That's
so
equivocal, right?
That's observation, right? I mean, he wasn't there in 1984. He's there 35 years later looking
Precisely. So we
looking
don't
at
have
and
proof.
trying to assess it. And he made a logical assessment based on the evidence he saw. So for instance, there are new metal, aluminum frame windows in the building, right? DHR says, well, those don't count. Why? They're aluminum frame windows that were not the original old wood windows that, those of us like myself were old
Wood
enough to
windows are
remember.
better than the aluminum frame ones, but you'll have time on
necessarily.
rebuttal.
This is true.
Those break in the snow.
May it please the court, I'm Robert Embarrass. I'm of counsel to Mark F. Palomino, who is the counsel for the respondent, New York State Division of Housing and Community Renewal. 2 points, really, 2 basic points. The first is that the application of Operational Bulletin 95-2 was not improper here. This court held as much explicitly in Woodcrest and implicitly in Pavia. And this does not implicate the retroactivity concerns of Regina, because Regina distinguished between retroactive legislation or regulation that impacts substantive rights and impacts that are procedural and or prospective. So here, the substantive right is the right created by the 1974 statute that created the substantial rehabilitation exemption. What Operational Bulletin 95-2 did was to clarify the evidentiary standards that DHCR would use in evaluating an application for such exemption. And it's our position that such application does not implicate the retroactivity concerns that the Court of Appeals articulated in Regina.
Well, I mean, from their perspective, that's kind of a hard pill to swallow, right? Because I do massive repairs to my buildings in 1984. The standard is different, right? I'm relying on that standard. I keep moving forward. Then the standard changes. By the time the standard changes, over 15, 20 years have gone by. And I don't know about you, but I even banks don't have to keep their records that long. So it's really, there is an issue of fairness here that seems to not filter down in these policies and how they are implemented to these owners.
Your Honor, Operational Bulletin 95-2 states that for rehabilitations that were completed before the issuance of the operational bulletin, that consideration will be given to the extent of documentation required. And that leads me to the second point, which is that here, by any standard, the documentation was rather sparse. Now, of course, yes, the original engineer had died, and they could not get an affidavit from him. But nonetheless, when this proceeding was being adjudicated, they got the affidavit of Mr. Coca, the engineer, and as Justice Gonzalez pointed out, he was not able. He was able to, and as Your Honor also pointed out, he was not able to make definitive declarative statements. He made judgments based on what appeared to him in his professional judgment and experience to have been done decades ago.
So does that not have value? And I mean, because then what we're saying is, if you didn't have the foresight to keep all of your receipts from decades ago, too bad, so sad, I'm sorry. I mean, don't we want to encourage building owners to make repairs, to improve buildings, so that the citizens of New York have a good place to live?
That is the statutory policy, Your Honor, correct.
Is the problem here that the filing was so late in time, so many years after the renovation was effected?
That is certainly a problem, Your Honor.
But
and
is
I
it
can't really
dispositive?
Pardon?
I mean, is it dispositive? Because there are issues, when we talk about retroactivity, you know that we hesitate. You know that normally it has to be by statute or by agreement, right? To the extent that someone can't provide documents because all of a sudden they're surprised by a request for documents, that's one thing. But when they delay in applying for an exemption, is that the same thing?
Your Honor, I haven't used the word latches, and I can't use the word latches here because the regulation does not place on the landlord an affirmative duty to apply at any particular point. So I can't say that the landlord was derelict here. That is not legally an argument that can be made.
Appreciate that.
Thank you.
Very briefly, I would point out that at page 857 of the record, there is the agency decision called Clarista Management. The facts are identical. There, the architect passed away also. They had to get an engineer or architect present day to make an evaluation of the building. Did exactly the same. There is no distinction between that case and this way. The only distinction the DHR can come up with was, well, the successor owner couldn't get the records from the prior owner, so we're going to give him a pass on that. And that has never been the standard for anything. If individual apartment improvements, you want to prove renovations that were done years ago, you sell the building. The new owner, if he can't produce those records, the agency time and time again. And
I'm sorry, but I thought in Clarista a predecessor owner had performed the renovations.
Correct.
Opposed. Is that a distinction without a difference?
Yeah. The predecessor owner did the work, and for whatever reason, the successor owner didn't do its due diligence and get those records. There are, I would say, hundreds, if not thousands, of decisions from the agency and that have been affirmed by this court that says the successor owner is out of luck if he can't get those records. And now they've announced that this is their new standard. The landlord's bar is going to be jumping for joy if they look at this brief and say, "Wow, we don't have to worry about the records of the prior owner. I'm a successor owner, and I'm just going to submit this brief and say, hey, I couldn't get the records." That's the only distinction they can come up with on the Clarista case and this case. That was the only distinction. Otherwise, the cases are identical, and there they gave the substantial rehab on the strength of the affidavit, the strength of the statements of the prior owner. Here, the deceased owner, who was still alive when the application was filed made numerous statements that are unrebutted. The affidavit of the engineer is unrebutted. It's not like the agency went there and said, it doesn't appear that these were changed or that was changed,
But
right?
they found that in order to be entitled to this exemption, you would have had to replace 13 systems, and according to your friend here, you only proved 6 or 7. So you're missing at least half.
No, Judge. They conceded. It started out, and this is another thing also. The rent administrator's order denied the application on the ground that the building was a horizontal multiple dwelling with the building next door. We didn't prove rehab of that building, therefore, we don't get it. And the engineer's affidavit contradicted the DOB record. Now, goes on par. They still go with the horizontal multiple dwelling, but they don't address the affidavit of the architect. Instead, they say, well, you didn't renovate the commercial space. Well, that's never been a standard in substantial rehab. And you attached the new sprinkler system to the water main. Yeah, that's what they said in the second order. They said you didn't renovate the kitchens and the bathrooms of the commercial space, so you didn't do enough.
I thought typically that was the responsibility of the tenant.
Yeah, that is. But that's what I'm saying. They're ever changing. If you look at the 3 orders, there's always a different reason why they were denying the application. That went up on Article 78. They took it back on remand. They abandoned, and in this Article 78, they've abandoned the horizontal multiple dwelling argument. They abandoned the sprinkler system argument. They abandoned the commercial space kitchens argument. And then now they've come up with this new thing saying, well, you proved 8. You proved 8 of these systems. You needed 11, and we don't think you proved the other 3, even though nobody has rebutted that. And contrary to their own operational bulletin, then they didn't give my client the consideration of the fact that this was done 25 years or 15 years before the operational bulletin was issued, and records go. But you have the DOB records. The scope of the work that they did here, created kitchens, bathrooms, everything where there were none before, and to have to do structural work with tension rods across through every floor, I think it was more than enough to show that the unrebutted evidence that was submitted justifies the finding that the building is exempt.
Okay.
Sorry.
So back in 1981 and 1984, they did all that substantial renovations. Now, when they were doing when they applied for the exemption, and the DHCR looked to the attached or the other building, if they didn't do that, would your client have passed the test?
If they did,
If they did not say, well, you have.
They didn't assess if they didn't assess the other building.
oh, I think they would have, because otherwise I believe the rent administrator would have said, you didn't show that building, but you also didn't show 75% of this building. But this also goes back to, should they be applying that bulletin retroactive to 1984? I think that's important.
Thank you.
Thank you, Judge.
There's a lot to think about.
Thank you, Your Honor.
People versus Alexandros Lorentos. Last but not least.
Good afternoon, Your Honors. My name is Mark Zeno, and I represent Alex Lorentos. May it please the court. The Miranda waiver here was not knowing and voluntary. 19-year-old Alex Lorentos was in custody for a felony murder. He had been interrogated for 6 hours by detectives in the station house. A new prosecutor walked into the interrogation room, and Alex asked him whether he should have a lawyer present for questioning.
And the lawyer Mirandized him, right?
I'm sorry?
The prosecutor said the Miranda warnings again, right?
Right. The prosecutor didn't answer the question, said, I'll get...
What obligation was there to answer the question outside of advising him of his Miranda warnings again?
Well, the prosecutor has an obligation to elicit a knowing and intelligent waiver of Miranda. It's not enough to just check off a box and say, I advised him of his Miranda
But
rights.
what box checking are you alleging from the record here?
The fact that he read him the rights.
Right, and
checked them
he
off.
said he understood, and then he proceeded to continue the conversation that he had been having with law enforcement.
He said it was up to him whether or not only to speak with the prosecutor, but whether he wanted an attorney and could have one if he wanted to. So why isn't Mirandizing him and saying, that's up to you? If you want one, you could have one.
Well, he has an obligation as a,
You want him to answer the question affirmatively, right?
I do want him to answer the question.
But what requirement was there to answer it in the way you wanted him to answer it?
Well, there are a lot of ways he could have answered
Right.
it. He didn't answer
What's
it.
wrong with the way he answered
He didn't answer it, Your Honor.
How is the way that he answered him a violation of your client's constitutional rights?
Right. So in the way that he approached Miranda and the waiver, he didn't make it clear that his position that he was a prosecutor investigating a homicide, that he was a prosecutor looking to gather evidence against Alex in the homicide.
I thought your client said when he introduced himself and he said, do you want to talk to me? I'm a prosecutor, and your client said, and anything I say to you can be used against me. Didn't he say that?
Well, he said, I'm with the DA's office.
Right.
I'm looking into this shooting that happened.
And they've told me some stuff about what happened, right? So he's letting them know the cops have already told me what you said to them, right?
Correct.
Okay.
And he has an obligation to reveal what his role is and not deflect.
Is it not, are we talking about requiring ADAs to basically provide legal advice?
No, but if they're asked the question, should I have counsel present, they need to respond to that.
And say it's up to you, but these are what your rights are. You're entitled to have one if you would like to have one, and if you can't afford one, one would be provided to you. Where's the problem in that?
Problem is he could have said many things and should have said something different. He should have said, I'm a prosecutor investigating this.
What is your legal basis for saying he should have said other things?
Because my legal basis...
Grounded in case law, grounded in the Constitution.
Grounded in case law, Dunbar would be the case I'd rely on most heavily, where there's a preamble that vitiates or offsets the waiver that's ultimately elicited. In Dunbar, a very different case than this. I'm not going to say it's exactly on point. It was where prosecutors, it was a routine script in the Queen's DA's office that said they would, before they read the Miranda warnings, they would say things like, it's a good idea to talk to us, but I have to warn you.
Right, but this is not
these
Dunbar.
rights. This is not Dunbar, and
in any event, right? Did your client unequivocally invoke his right to counsel? Is that what you're arguing?
No, I'm clearly not arguing that, Your Honor. And that was argued below, and that is not the argument we're making here. The argument we're making here is he essentially concealed his role as a prosecutor investigating the case, trying to gather evidence against my client.
So now the standard that you would want this court to adopt on Miranda is that prosecutors are required to say that they're prosecutors, required to say what their role in the investigation is, in addition to advising clients of Miranda warnings.
No, I'm not asking for a bright line rule. I'm asking for when a defendant, a 19-year-old defendant, asks, should I get a lawyer here? I'm asking that
prosecutors then give legal advice.
Prosecutor give a meaningful answer, and if it involves legal advice,
Give me an example of what would have been a meaningful answer.
a meaningful answer is I'm prosecuting this case. I'm not the person to answer that question for you. Rather than
then
just
you're not, but then we would be here on a right, and we would be here
answer.
on a different argument, which is the prosecutor didn't answer the question, didn't give him his Miranda, didn't tell him he had a right to remain silent.
By the way, is this issue preserved?
This argument was not made below. Thank you.
You'll have time on rebuttal.
Good afternoon, Your Honors. Excuse me. Jared Walkowitz for the people. I do want to get into what my adversary just said. First, as Your Honors were initially pointing out, Cuts is a case this court decided where it said that rereading the Miranda warnings to a similar question that was posed here was sufficient. But in this case, the attorney, the prosecutor, did answer the question. He answered it in a neutral way. He said, it's up to you. That's answering the question. If my son comes to me and says, do I have to go to baseball practice tonight? And I'm in a good mood, and I'll say, it's up to you. That's an answer, right? It's now his decision. This was his decision. It's always his decision. And that's what the prosecutor...
But this is not baseball, right?
What?
This is not baseball. This is a 19-year-old charged with a very serious crime.
No, but it is up to him. And that is, Your Honor, the question is, when they're saying they're not answering it, this is a simple question of, yes, sir, this is your decision. And the way that he's phrasing it, my adversary is saying that he didn't identify himself. He said he worked for the Manhattan District Attorney's Office. He also said...
That doesn't mean he's a prosecutor.
Well, again, we could go back and forth about how someone would interpret that, but he was certainly not, we could say he was not hiding it.
We don't need that because on the videotape, the officer tells the defendant that the prosecutor wants to speak to him.
Precisely, right before he comes in, he says, we're gonna have the prosecutor come in. And another thing is when the defendant would not think that this is an adversarial proceeding, the warning itself says anything you say can be used against you in a court of law. So he's being told in the exact Miranda warning itself.
So I'm a little perplexed because we have, for example, the model colloquy, as in follow this and it works.
Okay.
Right? You know, you cover everything. We have the Miranda warnings the same way. And if I remember correctly, the brief talked about this as being an ethical question as well.
His brief called.
His brief, no, not yours, but an ethical question. And I don't see it going in that direction. I see your adversary's argument going more along the realm of what is the gold standard here? What is the better practice as opposed to what is required?
Well, the best practice here was what the prosecutor did. He answered the question, and he directly answered it. And not only that, he answered it in a meaningful way, Your Honor. He answered it at the exact point in the Miranda warnings where it came up. It says, you have a right to attorney. It's up to you whether you have one, but it's your right to have one. So he answered that question exactly at the point of those warnings where they became relevant. And so their whole entire argument that the prosecutor did something wrong here doesn't align with this record. This record, the prosecutor got the question, didn't hide who he was, even if I agree with Your Honor and to the extent you talked about that the defendant may not know that. He didn't hide it. He answered the question. And there's nothing about this case that would suggest that the defendant's rights were not, his waiver was not knowing or voluntary. And this court passed off on Cuts, which was in many ways worse than this because the prosecutor never answered the question in Cuts. It just said, re-explain the rights and gave him time to decide. So if there are no further questions for me, I would ask that you would affirm the defendant's conviction. Thank you.
Thank you. You have 2 minutes.
Cuts was a case that dealt with the issue of whether it was an equivocal invocation of the right to counsel. So different question than I'm raising here. But I do want to move on to how that interrogation was used. When waiver or not, the interrogation was admitted into evidence, and among other things, this prosecutor who ultimately tried the case and argued the case before the jury is recorded saying things like, I know you're lying, I know you knew this was going to happen beforehand, I know to a moral certainty you're lying to me when you're telling me you didn't know a robbery was going to take place or a gun was going to be used. give me a reason to believe you that you didn't know there was a gun. So putting aside the waiver, using the prosecutor's personal belief in the dishonesty of my client when he denied knowing a gun was going to be involved or a
And
robbery.
of course, trial counsel requested that those portions be redacted.
No, he did
So the
not,
issue's
Your Honor.
preserved.
No, he did not, and it's not preserved, but that's what interest of justice jurisdiction is about. When there's a manifest unfairness, a 19-year-old here convicted of felony murder on equivocal evidence, where a lot of that evidence was unfairly used against him, and I would ask that the court reverse in the interest of justice.
Thank you so much.
Thank you.